District Court of the State of Michigan is now in session. The Honorable Judge Sandra, Ference, Cicirelli presiding.
Good morning, students. I am Judge Sandra, Ference, Cicirelli, and I am pleased to be here this morning. I want to thank Mr. Rosser, your principal, and Mr. Dave Mason, who's here, I see right there waving at us. He always organizes this for us and works with Eric Lang and the people from the staff of the 18th District Court. 18th District Court is located in Westland. I serve there with Judge McConnell. He is my colleague there. And we hear cases that are misdemeanor cases, although we do hear some felony cases at the start of those types of cases. And I'll talk a little bit more about each of these as we go on. But this is Constitution Day that we are here. And before I get into that, I want to make some introductions. I know that we have our Westland City Council President, Mr. Jim Godbout, is present this morning. Mr. Godbout, thank you very much for attending. We have some members of the school board here. I see Ms. Carol Medell is here. Mr. Tom Buckaloo is here. And they attend almost every one of our court sessions, so welcome to them. We also have Ms. Shavonna Johnson with us. She's from the front office. Ms. Jill Simmons and Ms. Jen Curry are here as well. Mr. Don Harris, who is the president of the teachers. Mr. Harris, oh, good morning, Mr. Harris. I didn't recognize you. Sorry about that. Good to see you. Yeah, all right. We have Mr. Dave Hales from RISA. And I will introduce Craig Welcome. I don't know if I see him floating around, but he's in the back there, and he's the one who makes sure that this program can be aired on TV so you can watch it. We have Kieran Dickelman and Ms. Samantha Reeves, both teachers from Marshall. All right. As I said, we're here for Constitution Day, and I know you've been studying the Constitution. As related to the court, there are several of those. The Bill of Rights are the first 10 amendments. Several of those amendments are important to the court and to what we do here in the court. These are real cases, so I'm going to ask you to be very attentive and very respectful and quiet so that we can hear this, because these are the same cases if I was sitting at the courthouse I would be hearing this morning in court. We tried to put a variety of cases together so that you could see not only what types of cases are before us, but also some of the consequences by having some sentences here today. The Fourth Amendment, everyone knows about search and seizure. That's extremely important in our court. The Fifth Amendment, right, the right to remain silent with the Miranda rights, not to incriminate yourself, and that's another important amendment that we're always working with here in the court. We're going to get started this morning. You should have before you, I know, a packet that will tell you a little about some of the cases. On the record, calling the matter of Marwa El-Shamiri. This is case number 19-WE14709. This is here for a sentencing this morning. Good morning.
Good morning, Your Honor. May it please the court, Jay Yasso appearing on behalf of the defendant.
All right, and ma'am, your name for the record.
Marwa El-Shamiri.
All right. Mr. Yasso, have you and your client reviewed the pre-sentence report that was prepared in this case?
We have reviewed it, Your Honor, and it's accurate in its content.
All right. Did she spend any overnights in jail when she was first arrested?
No.
I don't believe so, Your
All
Honor.
right. Is there anything you would like to say on her behalf this morning?
Yes, Your Honor. Marwa is a high school graduate, Your Honor. She's currently attending the Ross Medical School. As you can see from the PSI report, this is really her first time offense. She's not been in trouble before. She's extremely remorseful. She'll be able to speak for herself.
All right.
And we're asking for the court's leniency in this matter.
All right, and Ms. El-Shamiri is here today on a retail fraud, which is shoplifting case. Is there anything, Ms. El-Shamiri, you would like to say on behalf of yourself? You don't have to say anything, but this is your opportunity to address the court before sentencing.
Well, Your Honor, I just want to say that I'm really sorry, and I can guarantee this will never happen again.
All right, so this has been a learning experience for you?
Yes, definitely.
What made you do that? Were you with friends, or you just kind of had a lapse of judgment?
Well, so,
Just had a lapse of judgment. It sounds.
yeah.
All right. The court's going to follow the recommendation of probation. There are fines and costs of $120, state mandated costs of $125. I am going to place you on 1 year of probation. Oversight fees are $20 per month. Conditions of probation, you're to attend the economic crime program, and that is a class to help you understand and learn about how, when people do shoplifting, how it affects not just you and your family, but other people as well. You're to remain out of the Westland Mall and all Kohl's stores, not just the Kohl's store in the city of Westland. Obtain and maintain school and or a job, and apparently you already have enrolled in that and you're doing that. 5 days on the voluntary work program. The court is going to give you an opportunity to keep this off your record by taking it under the delayed sentencing program, or the statute. That is 771.1. Excuse me. Any questions? We're going to have you go back over to probation. They will go over this with you again, put it in writing, get you started, and they'll give you the information for the economic crime program. All right, thank you, Mr. Yasso.
Thank you, Your Honor.
Good luck. Do we have these numbers? All right, so young people sometimes make mistakes. Older people sometimes make mistakes. We all do because we're human. And so there are several first offender programs that allow you to be on probation, and if you complete probation successfully and you stay out of trouble, then the offense is dismissed and won't be on your record. And this young lady, this was her first offense, so it was taken under the delayed sentencing statute. It always amazes me when people go to, especially to the mall or some of these stores, that they think they can get away with shoplifting, because we've had people come into the court, and I've had trials where the security officer there will come and testify that if this whole room would be covered in monitors. With the video cameras these days, they see you all the time. And I remember we had one gentleman from JCPenney come in, and he testified at trial that if I was holding this paper in my hand, their cameras are so good they could zoom in and read what is on the paper. So and then they have the undercover people as well. So if you're with a friend and they say, hey, let's do this, think twice, and just remember that. All right, calling the matter of Derek Jones. This is case number 18WE11502. This will not be in your packet. This is a Judge McConnell case.
Good morning, Your Honor.
Morning.
David Stevens representing Mr. Jones.
All right, Mr. Stevens, this is here today for a pretrial and a receiving and concealing of stolen property, correct?
That's correct, Your Honor.
Sir, your name for the record?
Derek Jones.
All right.
Your Honor, I did have an opportunity to speak to the prosecutor, and she was kind enough to agree to allow me to have a discovery order that would allow me to order reports and any videos in this matter. So we're asking that the matter be adjourned so that I can get discovery.
All right. Court has signed and entered a discovery order, Mr. Stevens. We'll make sure you get your true copy this morning,
Thank you, Judge.
and we'll get a continued pretrial date. Steve, do we have a date for Judge McConnell?
They never gave you a date.
All right, let's go to, do you need 3 or 4 weeks, Mr.
4 if
Stevens?
possible. If we could do it October the 17th, Judge, that's a Thursday, if that would work with the court.
That's fine. At 8:30?
8:30 is fine, Judge.
All right, court will set this for a continued pretrial on Thursday, October 17th at 8:30. And that, again, we'll make sure you get your
Very
discovery.
good. Thank you very much, Your Honor, and you have a good day.
Steve, do we have this mark for the kids? Like that?
They have numbers on the docket.
I hear. Sometimes lawyers want to get what we call discovery, and that basically is just information so that they can prepare the case, go over the case. So the court will sign a discovery order that will be oftentimes taken over to the police station, because now our officers have the body cams that they wear. They've always, for many years, had the cameras in their cars, and they can actually get the videotape, copies of the videotape. They also will get the police report and any other information that would help them prepare their defense for their clients. Next, we're going to do number 12 in your packet. Calling the matter of Devin McClellan, cases number 19WE19262, A, B, and C. Mr. Bayuk, good morning.
Good morning, Your Honor. For the record, Steve Bayuk alongside Mr. McClellan. Please state your name for the record, sir.
Devon McClellan.
All right, this is here today for an arraignment in pretrial.
Yes, Your Honor. With respect to arraignment, we'd like to waive a formal reading. Mr. McClellan understands the charges and the maximum penalty, and we're asking to stand mute.
All right, for purpose of the arraignment, court notes that Mr. McClellan stands mute. The court's entering a not guilty plea on his behalf. But I see, Mr. Baker, that you also have pre-tried the matter with Ms. Bona, correct? Or Mr. McNamara?
That's correct, Your Honor. At this time, Mr. McClellan would like to take advantage of the plea offer, which is to plead guilty to possession of cocaine, asking the court to take it under 7411, and in exchange the driving matter. Both of the driving matters would be dismissed.
All right, Mr. McClellan, is that your understanding of the plea offer this morning?
Yes, Your Honor.
Is that what you would like to do today?
Yes, Your Honor.
I see that you did sign this morning an advice of rights form here. Did you read and understand it?
Yes, Your Honor.
Do you have any questions of Mr. Bayuk or the court about any of those rights?
No, Your Honor.
Is anyone promising you anything today or forcing you in any way to have you enter into the plea rather than set these matters for a trial?
No, not really.
All right. So you're doing this of your own free will?
Yes.
All right. It is alleged, Mr. McClellan, that on August 17th of this year, you were on Julius Street in the city of Westland. Is that true?
Yes, Your Honor.
At that time, did you possess a controlled substance?
Yes.
And what was that?
Some cocaine.
All right, court has accepted the guilty plea on the A file, which is the possession of cocaine. We'll dismiss the driving matters, which are the no driving a vehicle without ever acquiring a driver's license, as well as the ticket of no proof of insurance. Mr. Bayuk, if I sent your client over to probation right now this morning for a drug screen, what would the court learn?
Would you be positive for a drug screen or negative?
Negative.
Negative? Okay.
You talking about for cocaine?
Yes.
For any drugs?
Negative.
Negative for cocaine. What about any other drugs?
I mean, I smoke every now and then.
Smoke? Marijuana?
Yeah.
So possibly positive for THC.
So he would be positive for THC, which is marijuana. All right. All right, I am going to refer Mr. McClellan this over to our probation department for a pre-sentence investigation and recommendation. Stop using the marijuana. Do you have a medical marijuana card?
No.
All right, so it's not a necessary thing. So we're going to have you stop using that, and we'll come back for sentencing October 21st at 8:30 in the morning.
No.
All right, so you'll go back over to the courthouse and you'll meet with probation so that they can give you a date, because you'll need to come back and meet with them.
Okay.
Right? And we'll see you then. Thank you, Mr.
Thank you,
Bailey.
Your Honor.
Another 21st, she'll come back to your final court date. You need to start probation that day. Yeah, I believe so. I think they were sent the file. I'm going to take it back.
All right. You saw that in this case, this is a drug case, possession of cocaine, a very serious charge. And I am referring this over to our probation department. Part of what our probation department does is they do an investigation. They will meet with Mr. McClellan, get some information about him. They will do another drug screen. And then they make a written recommendation to the court about what they would recommend for sentencing. Most times the court would follow that if our probation officer would have any questions about, here's what I'm thinking, what do you think, Judge? They'll come and talk to us and ask us what our thoughts are as well. but that's really important. Now, if we were at the courthouse, I may have just sent him over. I wouldn't have asked him for what would happen if he did the drug screen. I might just send him right over there, because a lot of times they're not expecting that. We want to make sure that he stays clean. Before I continue, I want to introduce some members here that are here with us this morning. I want to introduce Mr. Stephen DeWald as my main court officer. He's been with me all the time I've been in the court. We have Darlene Smolinski, my court reporter and secretary. We have a couple of the defenders, and they are court-appointed lawyers who represent everyone right from the beginning. The law has changed recently where we now offer court-appointed lawyers from the very first time you appear before the court for an arraignment. That would be Mr. Steve Bayuk, Mr. Darren Weinberg. And of course, we couldn't do anything without our prosecutor. We have Mr. Michael McNamara this morning with us, and he's with the group Fossil and Bone, and they do the prosecution in our court. The very first hearing that comes before us is called an arraignment, and that is even in a felony case or a misdemeanor case. And at that hearing, again, the person is entitled to have an attorney represent them and talk to an attorney. They most often, in fact, always do. And then at the arraignment, they're told what the offense that they are being charged with is, or offenses. And then they're also told what the maximum penalties of those offenses are. And then we address the issue of bond. Bond is imposed for two purposes. First is to assure the attendance of the person at the next hearing, and also to protect the public in some cases. So if someone's charged with a serious murder crime or kidnapping, something very serious, obviously we want to protect the public as well. But we usually, in the misdemeanor cases, we're focusing on making sure that they come back to court for their next hearing. And so we look at several things. We look to see, do they have any outstanding warrants from either our court or another court, other jurisdictions, because we do have that information. And that kind of helps us address the issue of bond. And of course, the seriousness of the charge is another crucial factor. All right, we're next going to call number 2 in your packet, another sentencing. Calling the matter of Safa Al-Shamiri, case number 19-WE-14708. Mr. Yasso, good morning again.
Good morning, Your Honor. May it please the court, Jay Yasso appearing on behalf of the defendant.
Good morning. Your name?
Safa Al-Shamiri.
All right. Are they sisters, Mr. Yasso?
They are, Your Honor.
Okay. And did this client spend any overnights in jail?
She did not, Your Honor.
All right. So she is here today also on a sentencing charge for retail fraud, which is shoplifting.
That is correct, Your Honor. Now, I've had a chance to look at the PSI report. It's accurate in its content, Your Honor.
All right. Is there anything you would like to say on her behalf?
Yeah. Ms. Al-Shamiri, Your Honor, is facing the judicial system for the first time. This is her first time offense, no priors. She is a high school graduate. She is also employed at a urology clinic. And again, I'll let her speak for herself, Your Honor.
Okay.
Thank you.
All right, Ms. Al-Shamiri, this is your opportunity to address the court before sentencing. Is there anything you'd like to say or add?
Yes, I do. First, I'd like to say good morning, and I would also like to tell everyone here not to make the same mistake I made. And you know, if you're ever around people, maybe bad influence, speak for yourself and don't give in to peer pressure, and know from right from wrong, because this can forever impact your life.
Thank you for sharing that. I really appreciate you doing that, because these students are middle school students. I'm sure they often go to the mall, either with parents or more likely with their friends, right? And sometimes it can be tempting at that age, especially if you're with your friends and they're saying, hey, let's do this or let's look at that. So thank you for sharing that. So
No problem.
You've learned something from this.
Oh, I for sure learned something from this experience.
All right, court is going to follow the recommendation of probation. There are fines and costs of $120. State mandated costs of $125. I'm going to place you on 1 year of probation. Oversight fees are $20 a month. Conditions of probation: that you attend the economic crime program. You're to stay out of the Westland Mall and all Kohl's stores, not just the one here in the city of Westland. Obtain and maintain either a job or school or a combination of those. and do 5 days on the voluntary work program. The economic crime program you'll be attending when you go back to probation. They'll give the information for that, and
Okay.
that's just a class. Because, Mr. Yasso, and I'm going to do that for your other client as well, because they did volunteer to come here before the students this morning, which is a very valuable lesson, I think, for the students, and especially because this young lady was very out and forthcoming with them. I'm going to take 3 days and hold 3 days of those work program days off in advance. I'll do that for your other client as well.
Thank you.
You're welcome.
Thank you,
All
Your
right.
Honor.
Any questions?
No. Thank
Okay,
you.
very good. All right, we have to go over back to probation, and they'll go over this with you again and get you started.
Thank you, Your Honor.
You're welcome. Do we have someone from probation? Do we have a probation?
He's not going to. Just, okay.
When I talk with some of the students, as I sometimes am invited to do, and I ask them of their sentencing, what kinds of things do they dislike the most? And it's usually the work program. And that's usually because they say, you know what, I might have to go out and clean up the side of the road and somebody might see me, my family or my friends, and so that can be a little bit embarrassing. But we are very careful about how we handle that so that it's not embarrassing, and there are all kinds of options. But that is certainly a component of our sentencing that we often will do. All right, we are next going to do number 9 in your packet. This is a drunk driving case and a driving on a suspended license. You'll notice that in this particular case, it's not just an ordinary driving on with a blood alcohol content of being intoxicated. It is under the new, what we call super drunk law, that said the blood alcohol content was 0.17 or more. Does anyone know what the legal limit in Michigan is? Yes, sir. 0.08, yes. If you blow higher than 0.08, you are legally intoxicated. So 0.17 is more than twice the legal limit. And so we have a new, fairly new law that addresses that. Calling the matter of Vicari Purdom, these are cases number 19WE16330. A, B, and C. Mr. Bayuk, good morning.
Good morning, Your Honor. For the record, Steve Bayuk alongside Mr. Purdom. Please state your name for the record.
McConnell, pardon, Your Honor.
All right, Mr. Purdom is here not only, Mr. Bayuk, for a pretrial on this matter, he's also here for a bond violation.
Yes, that's correct, Your Honor.
Let's address the bond violation. All right, so the students know that Mr. Purdom received a bond. He did post the bond. It was a cash bond. And he also had the conditions of his bond were that he not use any alcohol whatsoever and that he report to the court to do daily PBTs. And anytime there is a high blood alcohol content, that is a standard bond condition, at least in my courtroom. We want to make sure that he's not drinking. And someone that has that high of a blood alcohol content most likely has an alcohol problem, at least in this court's experience. So he was ordered to either come into the court every morning at 7:30 and do a daily PBT. He would have to go to the police station on the weekend, or to get on the sober link or an alcohol teller. It is alleged, Mr. Bayuk, that on September the 4th, your client on the sober link, which he chose to do, had a .015, and then a few days later, on September 7th, he had a .023. And it rolls all the way to .04.
Yes, Your Honor. Mr. Purdom and I did discuss the allegations. He does not wish to have a contested hearing, and he does admit guilt to the violations.
Mr. Purdom, what is he didn't understand about the court saying no alcohol use?
I understood.
Then why is it you are continuing to drink?
Your Honor,
Mr. Baker?
through my discussion with Mr. Purdom, I do believe that he is committed to being sober. I do believe he had a setback. He and I had a discussion about oftentimes what the court tells people about sobriety court, to change the people, places, and things.
That's right, people,
And
places, and things.
I think his failure to do that is what led to these violations, and I think he's taking this very serious moving forward, that he needs to change those things in order to maintain his sobriety. So we would respectfully ask this court to consider one last opportunity to allow Mr. Purdom to comply with the conditions of bond. I do believe he's committed to it. He has been attending AA.
That's my next question.
Yeah, he has been attending, and he is informed me that it's been very helpful to him, and that he wants to use the things that he's learning there moving forward to remain sober.
This is the second offense, Mr. Baker? Looks like this is 2018.
There's an ongoing case that's in Wyandotte that's unresolved at this time, Your Honor,
So he has another pending drunk driving in Wyandotte.
pending.
Why is it I should not put this young man in jail so that he can learn not to use alcohol?
Well, Your Honor, you're right. You know, it's a strong, the addiction is a very powerful thing.
Certainly.
I do believe that Mr. Purdom is now finally taking the right steps to address that issue. I do believe he had a setback, and I think he understands why he had it, and he's going to make the appropriate changes moving forward so he's not in that position to use alcohol again.
How many times did he go into AA?
I believe on the sheet he's been there at least 5 or 6 times.
More than that, at least 7, 8.
Court's going to order that he attend AA in the interim before we come back for sentencing twice a week, minimum of twice a week for the violations. And so the students know normally on these violations they would come before the court immediately, but we wanted to have this held and heard before you so you could kind of see also. When the court says no alcohol, that's what it means. And we can monitor by the daily PBTs. A Sober Link is a handheld device that you can take with you wherever you are, and you can use it. Or we, in some cases, we use the alcohol tether. All right, let's move on now, Mr. Babe, to the pretrial. I see you met with Mr. McNamara. Mr. McNamara, were you recommending anything at this point?
Yes, Your Honor, and speaking with Mr. Bayuk and looking at the circumstances, I believe we are able to resolve the underlying case with a plea. It's my understanding the defendant will plead guilty to operating while visibly impaired by alcohol, as well as allowing a suspended person to operate a motor vehicle. The waivable defective equipment charge would be dismissed. And as the court knows, we were before Your Honor earlier, and one of the conditions we discussed at that time was that the defendant do treatment in order to get the underlying case resolved.
All right, thank you. Mr. Bayuk, is your client in treatment yet?
No, Your Honor, outside of, he's just been doing AA. Is that
And
accurate?
he's to immediately get into treatment. Mr. Pardon, if you need some referrals from our probation department, they will make some recommendations to you, refer you to certain agencies. There are some that offer services based on ability to pay, so you're to begin that immediately. All right,
So you gotta
is
be in
that,
substance abuse counseling.
Mr. Purdom, your understanding of the plea offer this morning?
Yes.
Is that what you want to do?
Yes, Your Honor.
I see that you did also sign this morning an advice of rights form. Did you read and understand that document?
Yes.
Do you have any questions of Mr. Bayuk or the court about those rights?
No.
Is anyone forcing you today to enter into the plea?
No.
It is alleged that on July 14th of this year, they did allow someone with a suspended license to operate your vehicle on Merriman Street in the city of Westland. Is that true?
Yes.
That would be yourself?
Yes, Your Honor.
On the C file, the court accepted the plea to that charge, dismissed the underlying charge and the civil infraction. It's also alleged, Mr. Purdom, that on July 14th of this year that you were driving that vehicle yourself on Merriman Road in the city of Westland. Is that true?
Yes, Your Honor.
Had you been drinking before that time?
Yes.
What was it you had to drink?
I had a couple of shots.
liquor.
Couple of shots, were those alcohol shots?
Yes, ma'am.
What kind of alcohol?
Douce.
Would you agree that as a result of drinking those shots and other alcohol, that your ability to operate the vehicle at that time was impaired?
Yes.
Courts accepted the plea to operating while visibly impaired on the B file, dismissed that underlying charge. Mr. Purdom, let me be clear. If you come back again with a bond violation, you'll be going to jail. Do you understand that?
Yes, ma'am.
All right. I'm going to refer this over to probation for a pre-sentence investigation recommendation. Mr. Bayuk and Mr. McNamara, he may be a good candidate for our sobriety court.
Your Honor,
Yeah.
he actually lives quite...
Oh, he lives in Ohio.
He does.
All right, so he's not qualified then for our sobriety court. All right, let's get a sentencing date. Is your client working currently, Mr. Bay?
Yes, Your Honor, he works at Chrysler. However, he and I had a discussion that they may be striking, and maybe you've seen that.
Yeah.
So he's kind of in limbo right now, but he does work for Chrysler.
All right, we'll see everybody back court October 14th at 8:30 for sentencing.
Yes, Your Honor.
We're going to have Mr. Purdom go over to probation so they can give him an appointment date to come back in. Also, he is to meet with someone regarding some treatment referrals for
Yes, Your
immediate
Honor.
treatment. I expect to see that he's attending regularly when he comes back
Yes, Your
for
Honor.
sentencing. And he's to immediately begin attending AA twice a week.
Yes, Your Honor.
Any questions?
No, Your Honor.
All right. We need to go over
When you
that.
go
We'll see you
over-
back in October.
Thank you.
Thank
you. Thank you.
When you go over to October, when you go over to probation, they can give you a list of places that do treatment, and those places probably offer AA at the same price. So when you go to probation, just ask them for it, say, where can I do treatment? They'll show you where you can do it. You're gonna have to do it.
One of the cases that I don't think you'll be seeing, at least on my docket this morning, is driving on a suspended license. And I just want to take a couple of minutes. I know you can't drive yet, but you're getting there, right? And soon you're going to, a couple of years or so, you'll all be taking driver's education. And I'm sure you can't look forward any faster than the day you're able to drive yourself. If you get a traffic ticket, it's extremely important that you do not ignore it or forget about it, because if you do not come into court timely, the Secretary of State will suspend your driver's license. And oftentimes people will come before us on a driving on a suspended license case, which is a misdemeanor, not just a traffic ticket, it's a misdemeanor, and say, oh, the reason my license got suspended is because I had this ticket and I forgot to come in and take care of it. And the courts, especially our court, we offer now even online that you can take care of traffic tickets. So we make it very easy to do, but it's extremely important that you do not forget about any traffic tickets that you get. So if you have any brothers or sisters, and sometimes mom and dad, make sure you remind them that they need to take care of their traffic tickets as well. So their license isn't suspended and they're driving to the store, to church, or to school, and they get stopped and arrested. We're going to do number 8 on your packet this morning. Calling the matter of Michael Anderson, cases number 19-WE19470, A, B, and C. These are here this morning for an arraignment and pretrial on the hindering or resisting arrest, as well as some traffic matters. Mr. Weinberg, good morning.
Good morning, Your Honor. Darren Weinberg, behalf of Mr. Anderson. Please state your name for the record.
Michael Anderson.
Your Honor, again, for purposes of arraignment, we waive a formal reading and stand mute.
All right, court notes that Mr. Anderson stands mute, has entered a not guilty plea at this time for the purpose of the arraignment. As to a pretrial, I see you're asking for some discovery.
Yes, We just need maybe 3 weeks or so for an adjournment so that I can do some follow-up stuff with a couple issues that Mr. Anderson has. So we don't need a long time. 3 weeks would be sufficient.
Do you need a discovery order, Mr. White?
Not at this time, Your Honor.
All right. All right, let's look at 3 weeks.
Wednesday or Thursday, morning or afternoon, better.
October 9th. You want morning or afternoon?
You said morning, correct? Morning, please, Your Honor.
All right. We'll set a continued pretrial, October 9th at 8:30.
Thank you, Your Honor.
You're welcome. All right, Mr. Weinberg, I'm going to ask you just to take a minute, if you would, and talk to the students a little bit, because they see that these individuals, some of them are coming in for an arraignment. I've explained to them that that's the hearing where the court would tell them what they're charged with, specifically what the penalties are, and an address bond. And you've been standing mute on some of those. Maybe you can explain to the students why your client would choose to do that.
It's just because they've already been informed of what the actual charges are and the maximum penalties by the discussion with the attorney. So instead of doing it again on the record, they just waive a formal reading and stand mute, and the judge enters a plea of not guilty, and then they'll come back another day for a pretrial. So it's just instead of being redundant and doing it over again.
Right, instead of the court having to read specifically everything, they already go over that with the attorney, and so then they're prepared to plead not guilty. All right, Mr. Weinberg, is this your next case?
No, it is not, Your Honor.
Okay. Well, we're next going to do a sentencing of a drunk driving case so that you can see what the penalties are. And that might give you some idea of not only what these individuals expect, but what they have to do, in addition to paying fines and costs. Calling the matter of Georgika Spataru, case number 19WE12570. Again, this is number 13 in your packet. Good morning.
Good morning, and thank you, Your Honor. Stephen Vitale on behalf of Mr. Spartario, who's present standing to my right.
Sir, your name for the record?
Georgika Spatario.
Mr. Vitale, did your client spend any overnights in jail when he was first arrested?
Yes, he did. I believe he has credit for 2 days, Judge, is what he
Okay,
has.
very good. And have you and he reviewed the pre-sentence report that was prepared?
We have reviewed the pre-sentence report, Your Honor. I don't ask Your Honor to make any additions, deletions, or corrections to the report. On his behalf, Your Honor, I want the court to know that Mr. Spartario is 50 years old, and this is his first offense. He's never before had any contact with the criminal justice system. He's currently gainfully employed, Your Honor, and he has asked me to relay to the court that he has a great sense of embarrassment and shame that at 50 years old he's standing before a court for the very first time. Okay. He's asked me to convey to Your Honor that if Your Honor were to be compassionate enough to follow the recommendation of probation, that he'll be a model probationer for the court. Thank you.
You're welcome. Mr. Spatario, this is your opportunity also to address the court before sentencing. Is there anything you would like to say or add?
I just wanted to say very embarrassing what happened to me. It's the first time in my life, and never gonna happen again.
Okay, very good. You've learned from this.
Never ever.
Oh, very good. All right, the court is prepared to follow the recommendation of probation. There is a fine of $300, court cost of $420, and state mandated costs of $125. I'm going to place you on 1 year of probation. Oversight fees are $20 per month. Conditions of probation, you're to pay restitution to the city for the cost of your arrest.
Yes, Your
Honor. Of $325. Pay the alcohol evaluation fee of $125. You're to attend the MAD Victim Impact Panel, as well as the Alcohol Awareness Program. And when you go back to probation, they'll give you the information for each of those classes. Not consume any alcohol, frequent any bars. You'll be asked to submit to random PBTs. Do 5 days on the voluntary work program and 2 days in jail with credit for 2 served. Looks like you did post a bond, so they'll apply the bond first of all to fines and costs. And they'll go over this with you again talk to you about making payments as to the balance. Any questions?
No, thank you, Your Honor.
All right,
thank you, Your Honor.
Mr. Downs.
Thank
All right, good luck, sir. All right, so you can see when it comes to a drunk driving case, the fines and costs total close to $2,000. So it is an expensive proposition, but we also make sure that we do random PBTs. And I will tell you at holiday time, we increase that. What holiday do you think is the most times that people get arrested for drunk driving and it's a big drinking holiday? Yes, ma'am. Not quite Halloween, but you're close. Yes, sir. Yes. Close second. A close second. The busiest times and the most times that people are drinking is the day before Thanksgiving. And the reason is because we have a lot of college students that are gone to school, right? Well, usually they come home, and that's usually the first big holiday that they are able to come home for, and they get together with their friends. So you'll find that statistically that's a super busy time for drinking. We always, on the day before Thanksgiving, test. We bring people in all the time. Also during the Christmas holiday season, there's a lot of Christmas parties. And that's another one. Obviously, St. Patrick's Day, so we make sure that for people on probation, we do extra testing on those days because we want to make sure that they're not drinking, but more importantly, that you are safe out on the roads and the streets. So that's extremely important. Under our ordinances, some offenses, you have to pay restitution to the city for the cost of the arrest, and what that is because the officers are spending time addressing those issues, and that helps the city out as well by recouping some of their costs of drunk driving. The MAD Victim Impact Panel, everybody goes. It doesn't matter whether your blood alcohol content was 0.09 or 0.2, because that's an extremely important program. I think it benefits everybody, even those who have not been convicted of any driving offenses, because it shows you what can happen when you're out there drinking. Those cars and vehicles are so big these days and heavy, they're kind of like a weapon. And so the court's very aware of that. We make everybody attend the MAD Victim Impact Panel. What other terms that you will do will vary depending, again, is this a first offense? Is this low blood alcohol content versus a high blood alcohol content? And we look at all of those factors when we decide what the sentencing is going to be. Before I go forward, I want to introduce a couple more people that just come in. I saw Mr. McNeil came in. He's on our school board. Mr. Neal, welcome. Thank you for attending. Ms. Sherry Grove. Good morning, Ms. Grove. Good to see you again. She is here. And Kate Broll and Tanya Karpinski are here from the school district as well. Good morning, and thank you for attending. All right. Go ahead and more. Any questions as to what you have seen so far on the cases that have come before you this morning? No? Or just like I mentioned to you about the traffic tickets, if you forget or you don't take care of your traffic tickets, then the Secretary of State will suspend the driver's license. Our court issues bench warrants for failing to appear. And so I have a few people, number 10 on in your packet there. Miss Elizabeth Moore was supposed to be here for a pre-trial. She decided not to grace us with her presence, and so therefore I'm going to issue a bench warrant instead of bond. On the record, calling the matter of Elizabeth Frances Moore, cases number 19-WE16659, A, B, and C. These are charges of disguising identity, driving on a suspended license, and then there's a traffic ticket. Failing to yield, causing an accident. I will tell you that in my courtroom, victims are extremely important. So even on a case like this, Ms. McLaughlin, is Ms. McLaughlin here? Would be notified to come in because we want to make the victim whole, meaning that if there's any restitution owed, court will definitely order that the defendant pay restitution to that individual. So in this case, it's a traffic accident. If this person, the victim, had car insurance, which is required by law, and had to pay only the deductible, then the court would order that the defendant pay the amount of the deductible to the defendant. There's current case law out there that says people can get wage loss if they, for the time that they have to come to court. So restitution is extremely important in our court. All right, court notes this matter was scheduled for 8:30 a.m. It is well beyond that. Ms. Moore has not appeared. She's not contacted the court to request an adjournment, indicate that she's running late. Therefore, the court is issuing a bench warrant, setting bond in the amount of $5,000, 10%. What that means now is she, first of all, the court doesn't just do that and surprise people. We will notify her that the court has entered a bench warrant and set a bond for her arrest so that she can then come in voluntarily. Otherwise, she may again be driving down the street, get pulled over for a traffic ticket or something else, and get arrested for failing to appear in court. I set a bond of $5,000, 10%, meaning that she would have to post $500 to be released from jail. And our officers would, if she had that immediately or she made a call and somebody would come in and post her bond, then she would be released with a court date. Otherwise, she'd have to stay in jail until she's brought before the court by our police officers. Calling the matter of Frederick Coachman, case number 19WE18464, A and B. This matter was scheduled for an arraignment and pretrial at 8 a.m. The defendant has failed to appear, therefore the civil infraction is defaulted. The court is also going to issue a bench warrant setting bond of $5,000, 10%. Usually I am one of the judges I set, in fact I did set about 13, as you saw, 13 or 14 cases because that lets us kind of talk to you about different kinds of cases. And we like to get those cases varied so you see different things. This is the first year, all the years I've been doing this, that a lot of my defendants have not appeared this morning. So we're going to be issuing some more bench warrants. But I wanted to talk about a couple of other things. So I'm going to talk a little bit and ask about questions you may have. Our docket is changing in the courthouse, not just here in the city of Westland, but in all of the district and area courts, because a minor in possession, do you know what that is? Anyone? That is if you are under the age of 21, yes, sir, then you could be charged with a minor in possession of alcohol, even if you just possessed it. That used to be a misdemeanor, punishable by up to 93 days in jail, fine of up to $500, both court costs and probation costs. The legislature changed the law on that, and that now is a civil infraction. So the first time someone would be caught with alcohol and they were under the age of 21, they might have a fine of $100, but it escalates. So if they do it again, then the amount of the fine and the penalty increases. So that's changed our docket. We don't see those as much. And in the springtime, which is obviously what you might expect to see, we would get a lot of those with graduation parties or other types of parties where we have minors charged with that because they possess alcohol. The other big change in the law, and a more recent change, is the decriminalization of possession of marijuana. And when I go speak in the schools, I will tell you that those are the most frequent questions that I get asked about, and everybody's very attentive because they're always interested in what's going on with that. Again, that used to be a misdemeanor. It was a drug offense, and that now has become a civil infraction. But again, the penalties increase for increased number of times. So So I'm sure you're all aware of those types of things. But again, on the drug offenses, even with the gentleman that appeared this morning for the possession of cocaine, under the Controlled Substance Act, there is a clause that allows for the first-time user, or first time the person's been caught and brought before the court, an opportunity to keep the offense off their record. And so if they, again, complete probation, stay drug-free, not get into any other trouble, then it would be dismissed at the end of that time. Now, that offense and that statute allows for that to be a non-public record. So what that means is if you go and you apply for a job somewhere, your employer would not have access to that information. So those are the types of things that are important. All right, Mr. McNamara, you as our city prosecutor, obviously the students did see some pleas today, which means that some of the offenses they're offered a reduced charge. What do you look for when you're trying to decide, should you offer and reduce the charge, and if so, to what?
Thank you, Your Honor. As Judge Cicirelli just indicated, sometimes when a charge shows up on your record, whether it be your employer or a subsequent criminal case that you're charged with, it makes a difference what is on your record. I look at the history of the person in front of me. Is it the first time that they've made a mistake? And the first time they may have made a mistake in this type of an area, whether it's a drug case, an alcohol case, a theft case, or some type of an assault case. So I want to look at the past history, take that into consideration. Obviously, I look at the police report and I speak with the witnesses to try to determine what actually happened and what proofs I have available going forward, as well as the age of the defendant. There's a deferral specifically for people under 24 years of age, where if they want to take responsibility for it, they can, with an opportunity to keep it off of their public record. Even though there's deferrals for certain aged people or a first drug offense, that is still available to the prosecutors when we're trying to decide what type of a plea offer to make. So you don't always get that first chance where you're in front of a prosecutor and they don't know that. That is one of the factors I look at is the history of the person in front of me, as well as the overall case, the age of the defendant. How serious is it? Was somebody hurt? Was there a car accident or a victim of an assault? And what were the extent of those injuries? Because we're always trying to make sure that the victims are made whole to the extent that we can.
And again, the victims, we always notify the victims. They will come in and they'll talk to the prosecutor, Mr. McNamara, whoever is there that day, because we want to get that information. We want to make sure that they are made whole. Remember, it's Constitution Day, that you have a constitutional right to have a trial either before the judge or a jury. You're entitled to a jury trial. And you do have jury trials in our court as well. We're known as the People's Court because that's usually the court most people might have to use or have some involvement with. It might be a traffic ticket that you got. Might be called for jury service. And that's another important civic duty that you'll have as an adult, is to serve on the jury. And I always talk to our jurors after they render their verdict and to find out what were they thinking. Was there one particular thing that that would affect their decision making? And almost every one of them, even though they might be reluctant to be chosen initially, indicated it was a really good experience and they enjoyed doing it. So that's another civic duty that you'll be looking forward to as well. Do we have any questions from our students this morning? We only have a few minutes left. Yes, sir. I didn't hear it, Mr. Mason.
What's the difference between a federal court and a district court?
The district court is a state court. So we are actually state employees as judges because it's a state court. A federal court, and there are federal district courts, that would be for the whole United States, and they cover a much bigger area. You'll find that they might have even cover more than one state, depending on the area. But the district court is what we do, and we hear small claims cases. We hear all of the misdemeanor and traffic cases. And as I said before, we do hear some felony cases. In fact, I just had a young girl's body that was discovered in Hines Park. That was just before me last Thursday for a hearing. We do the arraignment We will do the probable cause conference to determine whether there's enough evidence in the preliminary exam to go down to the circuit court. So if that is the case, then the case goes down to the Wayne County Circuit Court, and they hear the felony cases. We also hear civil cases, and sometimes people don't realize that. So if you are in a traffic accident and you're injured and it's not a real serious injury, we will hear that. We hear a lot of landlord-tenant. We hear a lot of contract cases as well. So that's our civil division.
We had
Mr.
another
Mayor.
question.
Yes.
What made you want to become a judge?
I wanted to become a judge because I see my role as judge not just to punish people. That's an important role in many cases. But I think in the majority of the cases, I see my role as helping individuals. And that is why I wanted to become a judge, is to help individuals. Certainly with the drugs. We are seeing so many people, not just young people, all across the age spectrum get hooked on drugs. Maybe they had knee surgery or back surgery. And then when the doctors won't prescribe anymore, they're out on the streets looking for that. There are treatment programs available. We want to get them into treatment. We want to help them change their life. I see ever since I've been there, two things that I'm proud of. One is our teen court at John Glenn High School, but also a sobriety court. Those individuals are on 18 months of very intensive probation where they come in every day initially. There's 4 phases to that program. We're helping them not just on a temporary basis, but change their lives. We give them the tools to find themselves in a situation where they might be tempted to drink, but they have other options available, and they do that, and it's a successful program. So that is why I wanted to be a judge.
There's about 1 minute left, but there was another question. What is your favorite part about being a judge?
Again, it's helping people. It's very satisfying to me when, and I will do this, I might be at Meijer's grocery shopping, or some people will actually come back to the court and thank me for helping them, and say, you know, you could have given up on me. You could have said, oh, that's it. Some of my family may have given up on me, but you did not. You helped me get the help that I needed, and you were compassionate enough to do that, and will actually thank me for helping them. And nothing's better than that feeling.
Question was, what's the difference between a felony and a misdemeanor?
A misdemeanor is you can be sent to jail for 1 year, up to a year. There are a couple that are what we call minor misdemeanors that sometimes up to 2, but if you could go to jail for a year or less, you come before us. A felony means you will be sentenced to more than a year in jail, and often those are your more serious crimes. All right, thank you, students. You've been so attentive, and I appreciate you allowing us to come and have court before you. Have a great day. Thank you, Mr. President.
I'll take that.
All rise. The 18th District Court for the State of Michigan is now in session. The Honorable Mark A. McConnell presiding.
Good morning. Please be seated. How's everybody today? Good. Always happy to be back here. I was counting on the way over here at Law Days and Constitution Days in the Wayne-Westland Community Schools. This is my 24th one. I know I don't look that old. Thank you. I appreciate that. And another person who's been here almost every time is Mr. Buckalow, who was in charge of putting it together at John Glenn when I first started in the city prosecutor's office back in 1996. And he's on your school board now, and along with Mark Neal, also on the school board, and Carol Medell, have taken time out of their schedules to come watch this great educational experience for you. Constitution Day celebrates the signing of our Constitution, which happened on this day in 1787, which set forth the foundation of our government, setting forth the 3 branches. Obviously, Article 3 talks about the most important branch, the judiciary, which is what the court is a part of. And we're always happy to be out here to give you an opportunity to observe what happens in our court. The cases that you will see today are real cases. This is what actually happens in our courtroom. And today our courtroom is here at your school to give you this great educational opportunity. So remember that when you're seeing these cases, that these are real people who have made mistakes in their lives and have been forced to come to court and have been very accommodating to us to give you this educational opportunity. I will introduce my court staff, and I'll tell you a little bit about what it is that they do. Right to my right is my court recorder, Carla Francesi. She is required to take down everything that happens in the courtroom. We are a court of record, so everything must be recorded, and that's what she does, is make sure that all the equipment's working, and if necessary, at a future date, can type out in a transcript everything that happened while we were here. Next to her is my court officer, Jim Dexter. He's a retired Westland police sergeant. He obviously, on today's date, makes sure that everybody stays safe in the courtroom and when he's at court, and brings the files in and out of the courtroom and makes sure that order is maintained. And to his right, we have one of our assistant city attorneys, Jacqueline Bona. She's the person responsible for prosecuting the cases. Mrs. Bona, tell us a little bit about your background.
Thank you. I'm Jackie Bona, and like Judge said, I'm one of the assistant city attorneys. So my role is to prosecute any city ordinances. And by prosecution, my job is to see that justice is done. And when you see trials going on, for example, on the television news, we're the ones that sit at the prosecutor's table and prosecute any crimes if they're committed in our communities.
All right, thank you. And to her right is another seasoned veteran of our court, Mr. Darren Weinberg, who's the court-appointed attorney, providing counsel to some of the defendants that have been charged with crimes here today. Mr. Weinberg, tell us a little bit about your background.
I've been an attorney for about 25 years also, as the judge and Ms. Bona. We've all probably been here maybe a couple years less than, fewer years than the judge for this event. I've been an attorney in the Westland area for about 25 years. I do primarily criminal defense as well as some license restorations. We're appointed by the court to help people that are requiring or requesting an attorney. There's 4 of us now that are handling this to help out people with their legal issues and try to address and make sure that their rights are upheld. And there's 4 of us now. There's another attorney, Mr. Bayuk, who will be out here later also.
All right, thank you, Mr. Weinberg. And with that, now we'll start with the cases that we have scheduled on the docket today. And you have a summary of all the cases, and this is case number 6 on your docket, People versus John Mercer. Good morning. You are John Mercer?
Good morning, Your Honor. Yes, sir.
Okay. Your appearance, please.
Good morning, Your Honor. William Allaire here on behalf of Mr. Mercer. Your Honor, this is the date, time, and place set for a arraignment pretrial on this matter. We've been able to meet with the prosecutor, and we have pre-tried it. The charges, the initial charges of reckless driving and drag racing have been dismissed, and Mr. Mercer will plead responsible to speeding 0 to 5 miles an hour on a limited access highway.
All right. Mrs. Bone, on behalf of the people, is that accurate?
Yes, Your Honor, that is an accurate rendition of the plea agreement.
Okay. So, Mr. Mercer, you were speeding more than 5 miles an hour over the speed limit on August 16th, 2019 at Ford and Vinoy here in the city of Westland?
Yes, sir.
Okay. All right, I will accept that plea. We'll take you back to the court to pay the fine with the cashier. And thank you for participating today.
Thank you very much.
Mr. O'Leary.
Thank you, Your Honor.
This is case number 5 on the docket, People versus Amelia Lamar.
Morning, Your Honor.
Good morning. And your appearance?
David Canine, last name spelled C-A-N-I-N-E, P61828, appearing on behalf of the defendant, Amelia Lamar.
And that is you, ma'am?
This is me.
Okay. It's my understanding that the prosecutor has spoken with your attorney and worked something out. Mrs. Bona, what is the situation?
Yes, Your Honor. Ms. Lamar will be pleading guilty to an amended charge to a motor vehicle code violation. She does have a very good driving record, and we felt that she would be deserving of the 0-point offense of the motor vehicle code violation.
And Ms. Lamar, is that your understanding of what you're doing today?
Yeah.
Okay. Before I can accept your plea, I have to certainly understand by pleading guilty, you're waiving all the rights set forth for you in this advice of rights form. Did you have an opportunity to read and understand these today?
Yes, I
Any questions about the rights you're waiving?
do. No.
You understand if I accept your plea, you will not have a trial of any kind? You can respond verbally?
Yes.
Okay. And nobody has promised you anything or threatened you in any way today to get you to plead guilty, have they?
No.
It's your own choice to plead guilty?
Yes.
And on August 29th, 2019, at Newburgh and Warren here in the city of Westland, you violated the Michigan Vehicle Code.
Yes.
I will accept your plea. Mr. Knine, satisfied with the factual basis?
I am, yes, Your Honor. Thank you.
If anything you want to tell me about your client before I impose sentence?
Just reiterating what Ms. Bono said, that she has a very clean record. This really is her first involvement with law enforcement, and it will certainly be her last. I would ask that the court take that into consideration.
And Ms. Lamar, anything you want to tell me about yourself?
That was just a stupid mistake, and it won't happen again.
Okay. All right, there's a $100 fine, $120 in court costs, $125 in mandatory state costs. We'll take you back to the courthouse, have you take care of that, and then you'll be all done with us, okay?
May she have a little time to pay that, Your Honor?
Sure, how much time? It's 3:45, how much time does she need?
3:45, is 30 days?
Sure, is that good for you?
Yes.
Okay.
Thank you.
You're welcome. Just in case something does come up, I'll give you till October 31st, a couple extra weeks. Obviously, if you don't come in and see us by then and don't pay it, then we issue a warrant and additional costs get added on, late fees, et cetera. So make sure you come in and either pay by then or see us by then, okay?
Okay.
Very good. Thank you, Your Honor.
Thank you.
Have a good day.
Thanks, you too. All right, this is case number 11 on your docket, People versus Brandon Price.
Ready, Your Honor. And for the record, Darren Weinberg on behalf of Mr. Price, who's approaching.
You are Brandon Price?
Yes, sir.
Okay. And Mrs. Bono, what's the situation?
Thank you, Your Honor. It's my understanding that the defense attorney would like a little bit of time to review some discovery, so he is requesting a continued pretrial so that the complainant can bring in a video of the incident.
And Ms. Weinberg, that's correct?
That is accurate, yes, Your Honor. As you can see, Your Honor, this is an older case.
Yes.
Mr. Price has made some significant steps over the last few months and years of trying to improve himself. He's working, he's in treatment, he's doing very well, but there's some discovery we need to see from the Target store to see if that's what exactly happened on that date.
Okay. Thursday, October 10th, Mr. Price, at 8:15 that date and time, okay for you?
Yes, sir.
Okay. All right, we'll give you notice of that in just a minute.
It's fine.
Are you sure?
Yeah, I'll have a piece of paper to show me what that is.
Yep.
Awesome.
There's your notice right
yes,
there.
sir. 8:15 a.m. All right, thank you.
Okay, you're welcome.
Awesome. The numbers there if you have any questions.
All right.
Okay.
Awesome.
Go back to the bus.
Okay. So, all right, so that case is, that's an example where the attorney wants to look at the video of the incident to see whether or not there are certain defenses that might be available to the representation of the client. So we always give people an opportunity to do that. That provides people with effective assistance of counsel. So that case will be adjourned for about 3 weeks. Have a chance to look at the video by then, by both the prosecutor and the defense attorney, and then make a decision on whether a plea is appropriate, dismissal, or some type of a trial. Case number 13 on your docket, People versus Ryan Sandra.
And again, Darren Weinberg on behalf of Mr. Sandra, who's approaching.
You are Ryan Sandra?
I am, Your Honor.
Okay. Mrs. Bono, what's the situation?
Thank you, Your Honor. This case had been adjourned from a previous pretrial date where the parties discussed a resolution. It seemed that the complainant had a matter where she was a defendant in Garden City. That matter was resolved with a dismissal just this week, and in return, she would move to request us to dismiss this matter on today's date. There have been no further incidences between the two of them. They are living separate and moving on separately.
Okay. And that's correct, Mr. Sanders, is your understanding of what's happening today?
Yes, Your Honor.
Is Madison Vachon here?
Yes, Your Honor.
Is that you, ma'am? Okay. And you have no objection to that resolution? Okay. All right, on the prosecutor's motion, the case is dismissed. You're free to go. Good luck to you two.
I appreciate that, Your Honor.
Good luck.
Thanks.
People versus Ronald Wayshick, case number 14 on your docket.
And again, Darren Weiberg on behalf of Mr. Washik.
You are Ronald Wasyk?
Yes, sir.
Mrs. Bona, what's the situation?
Thank you, Your Honor. This is another situation, Your Honor, where defense counsel is requesting an adjournment for discovery. He would like to review the police officer's body cam.
Okay.
That's correct. There's a potential issue of consent to search. I'd like to follow up with the video to see if it confirms what was alleged in the police report and what my client's position is. And then when we come back at a pretrial, we can try to resolve it at that point and see where the evidence is at that point.
Okay. Mr. Wasyk also has a probation violation for a case that he is on probation for at this time for failing to appear in July, failing to respond to a 14-day notice that was sent to him by the probation department, obviously picking up this offense as well. We will adjourn that show cause hearing on the probation violation to the continued pretrial date.
Yes, Your Honor, and I'm advising him to make a payment between now and the time he comes back. That was one of the issues that he had fallen behind on, and he is now employed, and we'll get to that at the hearing, but that was one of the complications. He is now employed and making money at this point, correct?
Yes, sir.
All right, that's good. Mr. Wasyk, Thursday, October the 10th at 9 a.m., okay for you?
Absolutely.
Okay. All right, we'll give you a notice of that, and then we'll see you back here on October the 10th, and I did sign that discovery order for you.
Thank you, Your Honor.
Case number 4, Matra Kapadia.
Your Honor, good morning. For the record, Steve Bayuk alongside Maitri Kapadia. Is that your name for the record?
Maitri Kapadia.
All right, good morning.
Good morning.
All right, Mr. Bayuk is another one of our court-appointed attorneys. If Mr. Bayuk could give a couple seconds to tell a little bit about your background and what you do.
Thank you, Judge. My name's Steve Bayuk. I've been an attorney for almost 6 years, and I've been working in the defender's office at the court for almost 5 years. I do mainly criminal law and just a little bit of property law, and just something I really enjoy doing and helping people who need the help.
Okay. All right. Thank you, Mr. Bayou.
Thank you, Your Honor.
Ms. Kapadia, it's my understanding that you worked out a plea agreement. Is that correct?
Yes.
All right. Mrs. Bona?
Thank you, Your Honor. It's my understanding that the defendant will be pleading guilty to the amended charge of allowing a suspended person to operate her vehicle, and in return, we would dismiss the original charge as well as the civil infraction ticket.
All right. Ms. Kapadia, is that your understanding of what you're doing today?
Yes.
Before I can accept your plea, I have to be certain you understand by pleading guilty or waiving all the rights set forth for you in this advice of rights form. Did you have an opportunity to read and understand these today?
Yes, I did.
Any questions about the rights you're waiving?
No.
You understand if I accept your plea, you will not have a trial of any kind?
Yes.
And no one has promised you anything or threatened you in any way today to get you to plead guilty, have they?
No.
It's your own choice to plead guilty?
Yes, it is.
On August the 8th, 2019, at Ford and Hicks Road in the city of Westland, did you allow a suspended person to operate a motor vehicle?
Yes.
I will accept your plea. Mr. Bader, satisfied with the factual basis?
Yes, Your Honor.
Anything you'd like to tell me about your client?
Yes, Your Honor. I'd like the court to know that Maitri is working. She's working at, in Canton at a restaurant. Your Honor, she did respectfully ask if she could have 3 to 6 months to pay this. She does believe she could pay it faster, but just to be sure that she pays it off in an adequate amount of time.
Okay. What's the status of your license now?
I think I have a ticket to pay off.
In Plymouth?
Yeah.
Okay. You're still suspended then?
Mm-hmm.
Okay. All right, anything that you'd like to tell me about yourself before I impose sentence?
No, that was just it won't happen again, and I'm just gonna try to pay off as fast as I can.
All right, so what I'll do to give you time to pay, I'm gonna put you on probation for 6 months. The probation costs are $120. Conditions of your probation, don't do any driving until you have a valid license. If you continue to drive, obviously things get much more hard for you to get your license back, because if you keep getting tickets and you stop, if you don't pay them, it gets really, really difficult. So make sure you come in when probation tells you to, and don't do any driving. There's a $100 fine, $120 in court costs, $125 in mandatory state costs. Once you pay everything, your probation will be terminated, so the sooner you pay, the sooner you don't have to come in and see us. Probation will, and when you go back to meet with them at court today, we'll give you a date to come in next month. Make sure you make a payment by that date. If you don't have the money, come in on that date and meet with probation. We can always work something out with you if you come in the front door and let us know that you're not trying to avoid the obligation, and give you more time if you need it. But if you don't come in, then we issue a warrant for you and add on additional costs. So please come in whenever probation tells you to, okay?
Okay.
Yes, Your Honor.
Any questions?
No.
No? All right, now we'll get you back to probation. They'll set you up on a payment plan over there, okay?
Okay.
Thank you, Your Honor.
So that's the second case that we've taken a plea on, and if you noticed on both of those cases, I went over this form, this advice of rights form with them to make sure that they have read it and understand it. And the Constitution sets out a lot of the rights that are included in this form, so it's important for each person, before I can take a plea from them, it's important that they understand that they're waiving all of these rights. And obviously one of the most important rights is the right to a trial in front of a judge or a jury, the right to assistance by legal counsel, which everybody has had here so far this morning, the right to remain silent at that trial, not have that silence used against you, the right to testify at that trial if you want to, and the right to remain in the courtroom the entire time the trial is proceeding, so that you have an opportunity to see everything that's going on, hear everything that's going on, and ask questions of any of the witnesses that testify. I noticed that the City of Westland Deputy Mayor and the purchaser for the City of Westland have walked in. So the Deputy Mayor is Michael Reddy. Thank you, Mr. Reddy, for stopping by. Devin Adams, the purchaser for the city, thank you for stopping by. So that's something that I have to do on every case when we take a plea. You also notice that I asked them some other questions about making sure that it's their voluntary decision to make the plea, and nobody's promised them or threatened them in any way to make that plea. And the Michigan court rules require that those things are established, that it's a voluntary and consensual plea before it would be a valid plea. So there's a lot of repetitive work that you have to do as a judge. And that's just a couple examples of it. And obviously, a lot of times we have a lot more cases than this when we're doing our regular docket. So I get to say a lot of the same things over and over and over again every day. So this is actually on the last judge's docket, and it's People versus Robert Davis. And if you don't have that paperwork, Mr. Davis is charged with hindering, resisting, interfering with a police officer by failing to identify himself during a criminal investigation because he had other warrants. He's also charged with driving while license suspended. And you are Robert Davis?
Yes, sir.
And Mr. Bayuk, your appearance?
Your Honor, for the record, Steve Bayuk alongside Mr. Davis.
And Mrs. Bono, what is the situation on this?
Thank you, Your Honor. It's my understanding that Mr. Davis will be pleading guilty to the hindering charge. The other charges would be dismissed upon acceptance of that plea.
And Mr. Davis, is that your understanding of what you're doing today?
Yes, sir.
Before I can accept your plea, I have to be certain you understand by pleading guilty you're waiving all the rights set forth for you in this advice of rights form. Did you have an opportunity to read and understand these today?
Yes, sir.
Any questions about the rights you're waiving?
No, sir.
You understand if I accept your plea, you will not have a trial of any kind?
Yes, sir.
And no one has promised you anything or threatened you in any way today to get you to plead guilty, have they?
No, sir.
It's your own choice to plead guilty?
Yes.
On August 23rd, 2019 at 1716 Merriman here in the city of Westland, did you refuse to identify yourself while the police were investigating a criminal case?
Yes, sir.
And you had some warrants out, is that why?
What did you say, sir?
Did you have warrants out of other departments?
Yes, I did.
Okay. Have you taken care of those?
I'm in the process of doing it now. I got rid of 3 of them so far.
Okay, that's great. And I will accept your plea. Mr. Bailey, satisfied with the factual basis?
Yes, Your Honor.
Anything you would like to tell me about your client before I impose sentence today?
Yes, Your Honor, if I may. Mr. Davis is 26. He does have 2 children, ages 4 and 2. He's living with his aunt. Your Honor, he's not currently employed at a job, but he does have skills in carpentry. He tells me he's been looking for work and doing some of his own business while he's been looking for work. And just lastly, Your Honor, this was a situation where the officers arrived on scene. Mr. Davis did identify himself by name. However, he did not at first tell the officers his birth date. It was later that he did finally corroborate and give them his birth date, and they were able to follow through with their investigation. So I did want to make the court aware of that. Your Honor, he does have a bond of $500 with the court. I wanted to respectfully ask if the court would consider giving Mr. Davis just a fine and allowing him to resolve it that way in lieu of probation.
Okay, thank you, Mr. Baby. Mr. Davis, anything that you'd like to say before I impose sentence?
No, sir.
Okay. Obviously, you do have some other issues in other courts, so we want to hold you up on those. So I will assess a $200 fine, $175 in court costs, $125 in mandatory state costs. Your bond will take care of all those fines and costs, so we'll take you back to the court, sign that bond over, and then you'll be all done with us. You can go on and take care of those other cases, okay? Any questions?
No, sir.
All right, good luck.
Thank you, Your Honor.
All right, so you'll notice that in the cases that I've sentenced people today, I've assessed state costs. We have a statutory obligation to assess $75 and $50 that go to the state of Michigan on every case that there's an adjudication on that we assess fines and costs for. The court costs, in addition to those state costs, the court costs go back to the court, and the fine goes back to the court as well. Ultimately, all of the fines and costs go to the city of Westland, so to help pay the deputy mayor's salary and purchaser. People versus Joe Harris, case number 2 on your documents. Good morning. You are Joe Harris?
Yes, sir.
And you are representing yourself today, is that correct?
Yes.
And it looks like you did a good job. Mrs. Bona, what's the result of his advocacy on his own behalf?
Yes, thank you, Your Honor. We have worked out a plea agreement with Mr. Harris. It's my understanding he'll be pleading guilty to the motor vehicle code violation. The original charge of the expired license would be dismissed, as well as the accompanying civil infraction tickets.
All right, Mr. Harris, that's your understanding of what you're doing today?
Yes.
Before I can accept your plea, I have to be certain to understand by pleading guilty or waiving all the rights set forth for you in this advice of rights form. Did you have an opportunity to read and understand these today?
Yes.
Any questions about the rights you're waiving?
No, sir.
You understand if I accept your plea, you will not have a trial of any kind?
Yes.
And no one has promised you anything or threatened you in any way today to get you to plead guilty, have they?
No, sir.
It's your own choice to plead guilty?
Yes.
And on August 11th, 2019, at Henry Ruff and Michigan here in the city of Westland, you were operating a motor vehicle in violation of the Michigan Vehicle Code?
Yes.
All right. I will accept your plea. What is the status of your license? I assume you're suspended from our court for failing to come in, correct?
Yes.
All right. And any other suspensions still?
No.
No? I'm looking at your record here. Looks like everything else is cleared up. And I think actually this might not have been suspended yet. Because it did come in a little late, but not too late that it ended up in a suspension. So anything that you'd like to tell me about yourself before I impose sentence?
No, sir.
All right. You need some time to pay?
Yes.
Okay. What I'll do is put you on probation for 6 months. Probation costs are $120. Conditions of your probation, pay a $75 warrant cost, $125 in mandatory state costs, $100 fine, $120 in court costs. Once you make all those payments, your probation is terminated, so the sooner you pay, the sooner you don't have to come in and see us. If you are told to come in on a date you don't have money, still come in so we don't issue a warrant for your arrest and add on additional costs. All right, any questions?
No, sir.
No, you do have some bond money that will go towards the fines and costs. We'll take you back to probation. They'll let you know what the balance is and set you up on that payment plan, okay?
Okay.
All right, good luck.
Thank you.
And you heard me say that $75 warrant cost on that case, and that's what we charge if somebody fails to show up for a court date, and then we have to issue a warrant. There's a lot of paperwork that is involved. I have to sign a couple different things. It goes into the computer system statewide, so if somebody gets pulled over and they find out who the person is and they find out that they have a warrant that we've set for them, then they'll be arrested and hopefully brought to our court. Now, the rest of these cases are all people that didn't show up today. We had a number of people that didn't show up today. They will be assessed that $75 warrant cost, and we will be issuing a warrant for their arrest. So case number 12 is People versus Stephen Rasinski. He was arraigned back on September the 9th and given today as his court date, and he's failed to appear. So we will issue a bench warrant for his failure to appear at the pretrial. We'll set bond amount of $7,510%. So he would need $750 cash if he were to come into police contact to get out of custody, so that he can come back to our court on another date. If he doesn't post that amount, then the police would bring him to our court the next available day. Case number 10, Sanchez Pointer. Mrs. Bono, what's the situation with that case?
With that case, Your Honor, the ordinance officer did appear today. I did have the opportunity to speak to him, and he filled me in on what had been going on since the last time we were in court. However, the defendant failed to appear, so we're requesting a warrant be issued for his arrest.
Okay. Failed to appear on a ordinance violation for pretrial today, so we'll issue a bench warrant, set bond amount of $3,010%. So that person would need $300 to get out of custody. Case number 9, Bianca Owens was given today's date for an arraignment pretrial, has failed to appear on a charge of driving while license suspended. And the civil infraction charge we thought would be really good for you guys, failing to stop for a school bus. But since she has failed to appear, we will issue a bench warrant, set bond amount of $7,010%. Case number 8, Patrick Olexi. Mr. Olexi was arraigned back on September the 4th, and I mentioned that word arraigned before. So what an arraignment is when a person comes to court for the first time on a criminal charge, and we tell them what the charge is, what the maximum possible punishment is. So in this situation, it's a receiving and concealing from the Meyer store on August 10th, 2018, and that's maximum possible punishment. Also with the retail fraud, 3rd degree, is 93 days in jail and or a $500 fine. He's failed to appear for the pretrial today, so we will issue a bench warrant, set the bond amount of $5,010%. Case number 7, Tony Gwynn. Just had a simple expired license ticket and failed to appear today, so we will issue a bench warrant, bond 5,010%. And for failing to appear on a driving offense like this, his record is otherwise clear. He doesn't have any suspensions. He just forgot to renew his license on time. But because he failed to appear here today, he's now going to have a warrant issued for his arrest, but also his license is going to be suspended because he didn't come in on this traffic ticket to take care of it when he was supposed to. So that's just an example of people taking something simple and making it a lot worse for themselves. So it's always best to come into court. If you ever have an issue, that's the best way to handle it. If you try to avoid it, it's never going to go away. The next case, Janice Facine, case number 1 on your docket, failed to appear for arraignment pretrial today. Issue a bench warrant, set bond amount of $3,010%. And you notice that I set different numbers for those bonds, and it's usually based on the severity of the offense or prior failures to appear in courts. I did allow everybody to introduce themselves, so I'll tell you a little bit about myself now that we've gotten all the cases handled, and I'll be available to take any questions that you might have, hopefully, if we can get a microphone out there for you. But I've been a judge for 10.5 years now in Westland. I guess I'll go way back in history. I graduated from Livonia Stevenson High School. I then went to Bowling Green State University in Ohio for my undergraduate degree. I got a Bachelor's of Arts in Political Science. And with a degree in government, you kind of have to go on to law school or something else. So I went on to law school at the University of Detroit. It's now called the University of Detroit Mercy, but my diploma says University of Detroit. One of the I think the last class with the old name. After that, I worked as a research attorney for the Michigan Court of Appeals for 2 years. So our court system starts at the top is the Michigan Supreme Court. Then we have the Court of Appeals. Then we have Circuit Court and the District Court, which are trial courts that have different types of jurisdiction over different types of cases. So I worked for the second highest court in the state doing research. And then went on after that, after 2 years there, and worked for Angelo Plakis and Associates, a private law firm in the city of Westland. We had a contract with the city of Westland to do its legal work, and I was my main duty was handling the prosecution of cases in the 18th District Court, where I've now been a judge, like I said, for 10.5 years. Our court system, the district court, is a limited jurisdiction court. We have jurisdiction over the beginning of felony cases. Those are the most serious criminal cases, and we do the original arraignments on those, and then we send them to the Wayne County Circuit Court for trials or for sentencings on pleas, if any are taken. Misdemeanor cases, the types of cases that you've seen here today, we handle from arraignment all the way through to sentencing. And our civil cases, we are limited to cases that are less than $25,000 in controversy. Most of our civil cases involve somebody who hasn't paid their credit card debt, haven't paid a doctor or a hospital bill, hasn't paid a friend back, or have paid their mortgage. That really pretty much summarizes most of our civil cases. Again, all less than $25,000 in controversy in those cases. So, Mr. Mason, do we have any questions?
We have our first question for you.
How long does it take to become a judge?
Well, you have to be a lawyer for 5 years, so basically go back to the school thing. After high school, a 4-year undergraduate degree, 3 years of law school, and then you have to be a practicing attorney for 5 years to become a judge. And then obviously you either have to get appointed by the governor if there's a vacancy, or and then re-elected, or originally elected in a citywide election. Hi, what's your name?
Chris Bonacci.
Chris, what's your question?
What is the difference between a district and federal court?
What's the difference between a district and a federal court? Okay, so I'm part of the state court system. As I just explained, we have the Supreme Court, the Court of Appeals, Circuit Court. It's actually a probate court that's kind of like the Circuit Court that handles probate matters, and the District Court. In the federal system, there's the United States Supreme Court. There's Circuit Courts of Appeals. Our Circuit Court is the 6th Circuit, and that is housed in Cincinnati, and it encompasses Tennessee, Kentucky, Michigan, Ohio. And then there are federal district courts. The Eastern District Court of Michigan has offices in Detroit, Ann Arbor, Bay City, and Flint. There's a Western District of Michigan as well. And those cases involve federal statutes, so criminal statutes that are violated that are federal laws. And then if there's on civil cases where there's an amount of controversy of $50,000, and they are involving people that are from different states. Okay, good question. Thank you.
Okay, tell the judge your name.
Earl.
Earl, what's your question?
What's the longest time you ever been away from the court?
the longest amount of jail time that I've given anybody. Yeah, most of our cases are city misdemeanor cases, so the most by law that I can give on those cases is 93 days, and I've done that a few times. We have some individuals that continue to come back to our court doing the same things over and over again after attempts at rehabilitating them through probation and other manners. They haven't been successful, so that really left me with no choice. I don't send a lot of people to jail. It's usually people that are repeating and doing the same things over and over again.
Okay, tell the judge your name.
Xavier.
Hi, Xavier. How are you?
I'm good. How are you?
Good, thank you.
What is the most interesting case you ever gotten?
The most interesting case I've ever had. Oh. That's a tough question. I think a lot of the criminal cases, the felony cases, are interesting. They're all unfortunately very serious, and usually means that somebody's been harmed in a very bad way. But those cases usually have good lawyers on both sides and have good issues, and they're serious. So I'd say my felony cases in general are the most interesting cases that I've had. Civil cases, I think I had a case where a woman sued to get her pet bird back, and that provided some, provided some great entertainment value, talking about the bird and things that the bird had done, and it was very interesting. It's a good question.
All right, tell the judge your name and then ask him your question.
My name is Christian, and what's your favorite thing about being a judge?
I think the favorite thing is I think I get to help people. Sometimes the people don't realize that we're trying to help them, but we have a sobriety court program where we deal with people that have 2 or more drunk driving offenses, and that has been really a great program because we really get to see these people make a great change in their life where alcohol is dominating their life and causing them all kinds of problems. By the time they're done with the program, they're not using alcohol. They've gotten promotions at work, or they've gotten a job or held the job for a long time, which they weren't able to do. They've started to work out, participate in sporting events, and have really improved their life, and you can actually physically see the change in them. So I think that's really the greatest thing about this job is the ability to help people, and especially in our sobriety court.
Tell the judge your name and then ask him your question. Demir.
Demir. What's your question, Demir?
If you street race, do you go to jail for that?
You could go to jail for that depending on what happens with the street racing. There could be a drag racing, which is a serious offense, reckless driving, which is a serious offense, or if somebody gets hurt during that activity, it gets a lot more serious where you could actually be charged with a felony depending on what happens if somebody's seriously injured or not. All right, good question. Don't drag racing.
All right, tell him your name and then ask the judge your question.
Okay, my name is Adrian, and I wanted to know why you didn't become like the higher court, like people who actually like do bad things. Like you only have people who don't drive right or something.
Well, we start with the people that do bad things before they go downtown. Why I wouldn't be a circuit court judge. This job, like you said, we don't, for the most part, we don't sentence the people. So I'm not sending anybody to prison for the rest of their life. So that's a good thing. And I would not want to do that. There are other types of law that the circuit court judges handle, the divorce cases. I don't want to be involved in a divorce case as a judge. I don't want to be involved in taking someone's kids away from them. I can't do that with this job. So I think it's a much better fit for me. But I wouldn't hate doing another type of judicial job. But obviously the consequences get a lot more serious. So, thank you.
Tell the judge your name and then ask him your question, please.
I'm Jordan Eichson, and how does a judge figure out if people are guilty or not?
Well, we have to, the prosecution in a criminal case has to prove a defendant, guilty beyond a reasonable doubt. So that's a high standard. And the way that I look at those cases, I have to listen to what the evidence is by testimony. So people will testify and tell their story about what happened. Sometimes those people are the victim of a crime. Other times those people are independent witnesses who observed something. And then obviously the defendant could testify, the person that is potentially could get in trouble. Also, at times we'll see video. A lot of times now we have, the police officers all have body cameras, So if that's something that's important, we can watch the video from the body camera. We can watch the video from the police car. We can watch video from cell phone or stores. There's video everywhere. Pretty much anything that's happening these days has a pretty good chance of being recorded. So taking a look at all of those things, and I have to make a decision on which I believe happened and didn't happen. Sometimes that's based on the number of corroborating testimony or evidence that there is, things that support one party's position or another. Other times it is just observing the way a person testifies. If they argue with the lawyers, if they act like they're not telling the truth, then I can take that into consideration when I'm judging their credibility to make that decision as well. It's a tough thing to do, to sit in judgment of somebody and try and figure out whether they're being truthful or not being truthful, but there are ways that we're trained to look for, and I use those skills to make those determinations. So, thank you. Good question.
Thank you, Your Honor.
Thank you.
Okay, tell the judge your name and ask him your question, please.
My name is Mo, and what made you be a judge?
I thought it was a nice transition for my career. I'd been in the city attorney's office for 13 and a half years, prosecuting a lot of the cases in the court that I'm now sitting in. I also thought it would be a great way to help people, and I really love the law, so I like looking at legal issues. I like doing research and things like that. That part of it, the job hasn't been as frequent as I would like it to be, but it still does give me an opportunity to do that, keep on top of all of the legal changes, because things are changing all the time in the law. So I like that aspect of it, and like I said, I like to have the opportunity to help people.
Okay, tell the judge your name and ask him your question, please.
My name is Daniel Price. And if you sue someone, how do you get your money, and what happens if you don't get it?
But if somebody doesn't pay their fines and costs?
No, like when you sue someone.
Oh, if you sue somebody, if they don't pay you? So if you go to civil court and you file a complaint against somebody, you get a judgment, ultimately, with an amount of money in it. And that judgment is really worth nothing unless you can collect on it. So there are a number of different things that people can do to collect on a judgment. And usually start with what's called a creditor's exam, where they'll have the person that owes the money come into court and testify about where their assets are. Once somebody finds out where their assets are, then they can do things like garnish a bank account, they can garnish somebody's paycheck, they can even start seizing property, like taking a motor vehicle that's owned free and clear and selling that off to satisfy the judgment. If somebody doesn't show up for court on one of those, for the creditor's exam, they can have a warrant issued for their arrest, and they can be arrested for that failure to appear. So there are a number of ways people can collect on judgments. Sometimes it can be hard, but there are ways that the law allows you to collect on a judgment once you get it.
Tell the judge your name and then ask him your question, please.
My name is Kelly De La Rosa. My question is, are you able to bias your punishment based on like the defendant's home life and situation?
Well, you say punishment. I don't do a lot of punishing. What we try to do is rehabilitate people and make them better. So we will take into consideration what their home life situation is like and try and fashion a remedy that will help them to get better. If there's a drug or alcohol problem in the house that's being perhaps passed on to them, we'll make sure that they get some type of counseling to learn how to deal with life without using drugs or alcohol. If there's an abusive situation in the home, we can require that there's anger management classes, domestic violence type classes to try and make sure that they deal with their anger in ways other than violence. So we do take those things into consideration.
Thank you. Tell the judge your name and ask him your question, please.
Christopher Massey. And what happens in a trial?
What happens in a trial? Well, in either case, either a criminal case or a civil case, the plaintiff, the prosecutor in the criminal case, the plaintiff has the burden of proving the case, and they do that by calling witnesses, by showing videos, by introducing documents, anything else that could be used to help me consider what the facts of the case are and make a determination. Okay. Thank you.
Any other questions? Tell the judge your name and ask him your question, please.
my name is Liz, and my question is, have you ever had any minors in your court, and if so, which was the worst case?
I have minors. Right now, the criminal law, you're an adult at 17, so technically that's a minor, but under the criminal justice system, that's an adult. So we do get a lot of 17-year-olds charged with misdemeanors, some with traffic offenses. Had a number of minors that have been victims of crimes, and I have to say those are the worst parts of my job, when there's a minor that's been a victim of a crime and I have to listen to them testify or somebody else testify about what's happened to this child. That happens too frequently, but that's the main way younger kids are in my court. We don't have jurisdiction of anybody that's under 17. So mainly minors that are victims would be what we would see the most. So.
Okay, we got time for maybe one more question. Anybody else? Going once, going twice.
All right, well,
all right.
Let's
give the judge a round of applause for being here, guys.
Thank you.
Please rise. The 29th District Court for the State of Michigan is now in session. Honorable Judge Laura R. Mack presiding.
Okay, be seated, everyone. Can you hear me okay? Okay. It sounded a little like an echo. Well, good morning, everyone. I am Laura Mack. I am the district judge in the city of Wayne, which is where this school is located. Actually, some of my employees at the court went to Franklin Memorial, or went to Franklin Junior High, or middle school now. My husband was born in Wayne, and he went to school all through his school years. He ended up at Wayne Memorial High School. He graduated in 1967, so quite a long time ago. But it's always a pleasure to come here to the middle school right in Wayne and talk to the folks that are going to be the future leaders of our country. It's very humbling to be in a position to offer you some experience that I've had being the district judge, and hopefully inspire some of you to go into law or go into government. And that's why I really like coming for Constitution Day, because the purpose of Constitution Day is to educate our students, our citizenry about our Constitution, which is a truly remarkable document. In celebration of Constitution Day, I'd like to first talk to you about the preamble, the beginning words of our Constitution, which is our plan for government and our highest law. The preamble explains not just why we need government, but why we need good government, and that's where you come in. The first three words of the preamble are "we the people," and they are the most important, in my opinion. Why did the framers, the people who wrote the Constitution, use the words "we the people"? They wrote and revised their words over and over and over again, so this was not a mistake. They did this deliberately. The framers wanted everyone to know that the power of the Constitution comes from we the people, from us. A good government gets its power to make law, which I am sworn to uphold, from the people, which is from you, not the will of a king or a tyrant. And that law applies to all of us equally. It is what we call the rule of law. Before the American Revolution, as subjects of the British king, Americans only had the rights that the king would allow them to have. Without the rule of law, many were jailed, lost their property, or were even executed without a trial, without even knowing what they were being charged with. The founders of our country realized that freedom could only be protected if our country had a limited government and a rule of law that applied equally to everyone. The framers also wanted to form a united nation that worked together rather than a group of individual states. For the Constitution to be effective, it had to be accepted by the people. Ordinary Americans debated what they liked and disliked about the Constitution before elected delegates voted to ratify and accept it. Only after 9 of the 13
original states had ratified the Constitution, did it become the supreme law of the land. The Constitution made rules not only for how the federal government should work, but also saved certain rights and responsibilities for the states, like Michigan. When Michigan became a state in 1837, the state constitution begins, "We, the people." So what do the U.S. and Michigan constitutions mean to you and your classmates? They give the U.S. and Michigan governments the power to make, enforce, and interpret laws, not just for adults, but for everyone. Attending school, speaking and writing freely, and the right to freedom of religion are among the liberties or freedoms we all enjoy. When you go on Facebook or Snapchat or WhatsApp or whatever those are, and you put whatever you feel, when you type that on there, you're exercising your right to free speech. And that's in our Constitution. The Constitution is very important to the courts, as it is to all three branches of government. And the courts are part of the judicial branch of government. And I think you've learned about the three branches of government. In particular, the Bill of Rights, which is the first 10 amendments to the Constitution, provide many rules and protections for persons who are accused of committing a crime. And our court deals with these, the first 10 amendments to the Constitution every single day. Those protections are embedded in our judicial system. And I'm going to ask you to watch for examples of the different amendments to the Constitution in the cases that you are going to hear today. And these are real cases. We are conducting real court. And there are 4 of the amendments that apply to the cases that you're about to hear. First and foremost, really, the 4th Amendment to the Constitution protects people against unreasonable searches and seizures by the police. This amendment governs all traffic stops. So when you have a policeman pull you over and say that you're speeding, that implicates the 4th Amendment, because stopping a car on a road is a seizure. It impairs your ability to keep going, and it's considered a seizure for some purposes under the law. So obviously courts like mine, the district court in the city of Wayne, we handle minor offenses. We handle traffic offenses, we handle misdemeanor crimes, and we handle civil property disputes up to $25,000, and landlord-tenant disputes, and also small claims, which if anybody's ever seen Judge Judy, has anybody seen Judge Judy on TV? Okay, that's what a small claims case is like. So we handle those as well. Those are not criminal, those are civil. We're not going to hear any civil cases today. The cases you are going to hear are criminal, and what makes a case a criminal case as opposed to a civil case is the penalty. In a civil case, it's only about money. Somebody's suing somebody for money or property, there's no liberty interest involved. Nobody's going to jail under normal circumstances in a civil case. In a small claims case, you never see Judge Judy say, take that person to jail, right? It's only about money or property. On the other hand, a criminal case involves liberty. Criminal is society's way of saying you did something wrong, and this is the punishment that you could receive. Criminal cases carry with it the possibility that you could be locked up, you could be put in jail. Now, for the cases that I handle most often, the misdemeanor cases, the most that somebody can go to jail is 1 year. If it's any more time than that, the case is called a felony, and that goes to circuit court for resolution. So you are not going to be hearing any felony cases today. You're going to be hearing misdemeanor cases, which is mainly what district courts deal with on a regular basis. And instead of having a trial, that would just take too long, and we don't have the time for that. So you're just going to hear one small part of the case that we call. We're going to go over the different phases of a criminal proceeding. The first phase is the arraignment. The second part is the pretrial, where the person, so the arraignment is where the judge tells the charge to the judge or the magistrate tells the defendant the charge that has been made against him or her. And they tell them the penalty, the possible penalty. and the rights that they have, including the right to have a trial. All of those are told to the defendant at the arraignment. So that's the first time the person hears why they are being arrested and why they are in front of a judge. That's the arraignment. Then, if the person pleads not guilty, it goes to a pretrial where the defendant meets with the prosecutor. And we do have our city attorney here today, Carrie Miller. And in a few moments, I'm going to ask her to talk a little bit about herself and the job that she does for the 29th District Court. Also, every person that's arrested for a crime or is charged with a crime has the right to an attorney. And we have an attorney that we employ through the 29th District Court who handles most of our criminal defense work. So it's his job to represent the people who've been arrested and to make sure their rights, including the rights that I'm going to go over that are in the Constitution, make sure that those rights are not violated and that the judge and the court system is fair to everyone. So the next phase in the trial is usually cases are resolved at the pretrial. There's what's called a plea agreement entered into. That's where the defense attorney, the defendant, and the prosecutor all agree that this person is guilty of something. Maybe it's a different crime, maybe it's a lesser crime than what they were originally charged with, but the defendant agrees to plead guilty to that charge. So then the judge takes the plea on the record, and everything we do today is on the record, by the way. We're recording everything that happens here. And then the case proceeds to sentencing. So some of the cases we have today are the last phase, which is the sentencing phase. And we'll go over the plea just so that you understand how the charge was arrived at, and then we'll go over the sentence with respect to those cases. But the amendments to the Constitution that I want you to keep in mind are the Fourth Amendment. I started to talk about that, which involves a traffic stop, police stopping someone, protects against unreasonable searches and seizures. The Fifth Amendment to our Constitution says no one can be punished for a major crime without first being charged, cannot be tried twice for the same crime, and cannot be deprived of life, liberty, or property without due process of law. Due process of law is what we're doing here today, meaning you're not just arrested and thrown in jail. There's a process. You have to be found guilty. You have to plead guilty. There has to be a finding. There has to be a process, and that process has to be fair to everyone. So due process is a huge part of what we do in the district court on a daily basis. The Sixth Amendment says that everyone accused of a crime has the right to a speedy and impartial trial. So our misdemeanor cases are handled very quickly. So people are charged of a crime are charged, and then they have their pretrial and they go to sentencing usually just within a couple weeks. It usually does not take more than 30 days to resolve a criminal case. The Eighth Amendment says that punishment for a crime cannot be cruel or unusual. So I have discretion in sentencing. I get to decide what the penalty will be when someone pleads guilty or is found guilty of a crime. So I cannot hang someone by their thumbs, you know. That would be cruel and unusual. I could not order that to happen because of the Eighth Amendment that we have. So not that I would ever do such a thing, but there are other things that judges have done that have been found to be cruel and unusual, humiliating to people, and there's really no need for it. So that's why we have that amendment to our Constitution. And I just want to close with a talk about the Constitution. Even though we celebrate this on September 17th, it is important that we, the people, Americans of all ages, remember every day as Constitution Day. We have a right and a duty to educate ourselves about our wonderful democracy that our founders created so that we can improve the lives of us all. And that means, to me, that you have to vote. And you have to vote intelligently. You have to educate yourself about the issues and the candidates and vote when you turn 18. When I was younger, I couldn't vote until I was 21. So the fact that you can vote at 18, I think, is a wonderful thing. And I think that everyone should exercise their right to vote. But you also have to educate yourself. And you all are learning about government. Really, to understand government, I really suggest that you come to court. Our court is open to the public. You can come and watch court any day. We just let our court officer know that you're there to visit and to watch. You can also go to a city council meeting They are open to the public as well. You can see how the lowest level of government, really the city government, how that functions. And I would urge you to get involved. You know, as a young person, get interested in campaigns, learn about them. When you get old enough, work for a campaign. I think it's really the best way to be involved in our democracy, which is really a wonderful form of government that we are really lucky to have. Okay, I'm going to now introduce our defense attorney, Charles Close, and ask him to say a few words.
Good morning. As the judge said, my name is Charles Close. I act as a defense attorney in the 29th District Court. My primary responsibility is to represent defendants who do not have an attorney. That responsibility includes making sure that each defendant has due process of law. Defense attorneys, in essence, make the prosecutor, whom I respect deeply, prove their case beyond a reasonable doubt, because everybody that I represent has a presumption of innocence, and it's up to the duty of the prosecutor to prove that person is guilty beyond a reasonable doubt. That is guaranteed in our Constitution, and my obligation is to make sure I make the prosecutor adhere to their constitutional responsibilities.
Okay, Ms. Miller, do you want to just explain in a few words your role as our prosecutor, city attorney?
Sure, thank you, Your Honor. Hi, my name is Carrie Miller, and I'm a city attorney for Wayne. There's multiple attorneys that work for Wayne, but my main job is to prosecute crimes on behalf of the city and on behalf of the Wayne Police Department. So the way that it works is, as Judge was explaining, that there's different branches of the government. The legislature passes laws. In cities, the city council will agree on ordinances or laws, and then they're put in place, and it's up to the police or different city officials to enforce those laws, and then up to me to prosecute them in court if they come to me. So if a police officer stops someone and thinks that they committed a crime, they would write a police report, and then that police report would come to me, and I would review it and decide whether or not a warrant should be issued in that case for a crime. Warrants are issued based on a probable cause standard, that you would believe that someone is more likely guilty than not, but ultimately in court, we would have to prove it beyond a reasonable doubt. So that's up to me to decide if we're going to go forward on a charge in court, and then to come to court and try to prove that beyond a reasonable doubt to the judge or to a jury, because everybody has a right to a judge or jury trial. When we put our appearance on the record, I would say my name is Carrie Miller and I represent the city, or a lot of times I would say I represent the people. And so the way that, as Judge was saying, that there's laws to have an order in society, we represent the people, the general public, to be free from crime or disruptions in the city. So we say we represent the people, and then that's my role.
Okay, thank you. Also with us today is Lamont Patton. He is our court officer at the 29th District Court. He makes sure that the process of a court is orderly, that people obey the rules of the court. He keeps order. He brings files to the bench and to the counter. And he is armed, and he also carries a taser. So if anybody got out of line today, he would be the one to escort you out of the courtroom and make sure that you didn't disrupt proceedings any further. Do you want to say a few words, Lamont, about what you do, Mr. Patton?
Hi, my name is Lamont. So the judge stated, my primary focus is obviously to make sure that the judge is protected as well as anyone that's in and out of the courtroom. We run a lot of files back and forth, carry out certain tasks for the prosecutor as well as the defense attorney. So have an opportunity to do quite a few things, interact with the public on a day-to-day basis.
Thank you. And then we have Carla Franceschi, right? Franceschi. She is the court reporter in Westland, and she has agreed to record these proceedings so that we comply with the law, which requires that everything that we do be on the record and be recorded. At Wayne, at the 29th District Court, I actually am the court reporter as well as the judge. I push a button on my computer and I record what happens in the courtroom. Okay, I think we are ready to begin with calling the cases. I'm going to call the first case, People versus Callian Campoy.
We're ready, Judge.
I'm sorry.
Good morning, Your Honor.
Morning.
For the record, Charles Close on behalf of Mr. Campoy. Your Honor, today is the date and time for sentencing in this matter. I've had an opportunity to review the pre-sentence report with my client. We discussed it at length, advised him of his rights with respect thereto. We have no addition, changes, or corrections to that pre-sentence report, and we're prepared for sentencing, Judge.
Okay. All right, Mr. Campoy, you have read over the pre-sentence report, and
Yes.
as your attorney said, you have no additions, deletions, or corrections.
No.
Is there anything you wish to say to the court before the court sentences you?
No.
Do you want to say
To
anything
them?
to the students?
Oh, yeah. You know, good people make mistakes. You really got to think what you're doing sometimes because it will definitely affect your everyday in your life.
Okay. You spent the night in jail?
Yes.
Okay, how was that?
It's not fun, you know. It's definitely not fun, and I spent 8 hours in the trauma unit because I got hit on my motorcycle without a helmet.
Ah.
So I could have lost my life.
Oh, you were in an accident as well?
Yeah.
Right. Yes, this was operating while impaired, and we already took the plea, so I won't go over that at this point. Okay, so it's not something you would recommend?
Not at all.
A bad decision?
Definitely.
Right. So I guess the takeaway is if you've had something to drink, call somebody.
Yeah.
Don't get behind the wheel.
Don't get behind the wheel.
You are lucky to be alive.
Yes, ma'am.
Okay. I am going to adopt the recommendation. You are going to be on probation with us for 1 year. That means you have to come to court to report with the probation officer monthly, or as often as the probation officer may require. Do not violate any criminal law of any unit of government. Do not leave the state without the consent of the court. Notify the probation officer immediately of any change of address or employment status. You did spend 1 day in jail?
Yes.
1 day jail with credit for 1 day served. You know that you could serve up to 93 days jail in this case.
Yes, ma'am.
But I'm not assigning jail at this point. I would normally make you do community service. I'm waiving that because you did participate in Constitution Day.
Okay, thank you.
You are to attend a Mothers Against Drunk Driving impact panel. You have to pay for that when you go. Attend an alcohol awareness class. Continue the current treatment that you're getting with Dr.
Cicirelli?
Zachariah. No going to bars, no associating with drug users, no alcohol, no illegal drugs. You are to submit to random alcohol and drug tests. Are you testing now?
Yes.
We'll continue that. As far as fines and costs, instead of a fine of $300, I'm willing to lower it to $200. Cost of $300, building fund fee $20, justice system fee $50, crime victim fee $75, cost recovery to city of $250, screening and assessment fee of $125, probation cost $240, probation coordination fee $100, and strike the work program. I don't have a calculator here, so I'm going to ask you to go back to the court and have them total it for you and also work out any payment arrangement.
Okay.
You did have a bond, it was posted by someone else.
Yes.
Is that person willing to sign it over for you?
Yeah.
Okay. So you'll have to contact the person who posted the bond.
Okay.
And have them sign over the bond. Okay? So I'm going to write on here that you will report to the 29th District Court for your probation appointment, payment plan, etc. All right? Good luck to you.
Do that today?
Yes.
Okay.
If you can.
Thank you.
All right, you're welcome. Michelle Lalonde, case number 18C12709.
We're ready, Your Honor. Charles Close on behalf of Ms. Lalonde. Your Honor, today is in fact the day and time set for sentencing in this matter. Ms. Lalonde and myself had an opportunity to discuss this matter She has read the pre-sentence report. It is factually accurate, Judge. We have no changes. We're prepared for sentencing, Your Honor.
Okay. Would you mind explaining to the students what the charge was?
It was a child abuse charge because I went into the store and left my kid in the car for about 7 to 12 minutes, and he was, I guess, too young to do that.
Right. And your child was okay?
Yeah.
Okay.
He actually went through my car and found a knife, and that's why they called the police,
Oh, my.
because he held it up at the window. And then when a person outside saw, he was like, "Oh yeah, my mom gave me this for protection," which was not true.
Okay.
But they called the police, so.
And how old is your son?
He's 6. He'll be 7 in
6,
October.
Okay. Okay. So it's not a baby?
No.
No. Okay. All right. I am going to adopt the recommendation. It's going to be a year initially, but I'm okay terminating your probation earlier, after 6 months, if you've complied with everything.
Okay.
Okay? Also continue the treatment that you're getting at Higuera, and also add parenting classes to that.
Okay.
Don't leave any child, defendant may not leave any child in her care under 12 years old unattended in a vehicle. And obviously no harm to your son. She's recommending 3 days of community service, but because you participated in Constitution Day, I am waiving that.
Thank you.
We just really want your child to be safe.
Me too.
Yeah. Okay, as far as a fine of 100, costs of 100, building fund fee 20, justice assistant fee 50, crime victim fee 75, probation costs of 240, probation coordination fee 100. Do you need a payment plan? Okay. So you'll get your payment plan back at the court. So you do need to report to the 29th District Court. And we do close from 12 to 1. So it'll probably be, you'll have to come after 1 then.
Okay.
Report to 29th District Court for payment plan, etc. Okay, anything else you want to say to the students, or that's about it?
That's about it.
Okay, all right, thank you.
Thanks.
Jose O'Day, case number 19WC02300.
Ready, Your Honor. For the record, Charles Close on behalf of Mr. O'Day. Your Honor, today is the day and time set for a pretrial in this matter. My client is in fact charged with operating while intoxicated, leaving the scene of a property damage accident, and no proof of insurance. I have had an opportunity to discuss this matter at length with the city attorney. She has generally made a generous offer wherein if my client pleads guilty to the amended charge of operating while impaired and failure to report an accident, that she would dismiss the original charge of operating while intoxicated, leaving the scene of a property damage accident, and dismiss the civil infraction, no proof of insurance.
Okay, Mr. O'Day, is that your understanding of the plea agreement?
Yes, Your Honor.
You do understand that operating a vehicle while impaired is a misdemeanor, punishable by up to 93 days in jail and/or a fine of up to $300 plus some very substantial costs, 4 points on your master driving record, suspension of your driver's license for 90 days, but you will be issued a restricted license by the Secretary of State if you're otherwise eligible.
Yes, Your Honor.
You understand that failure to report an accident is also a misdemeanor, punishable by up to 90 days in jail and/or a fine of up to $100 plus costs, but there's no points.
Yes, Your Honor.
You do understand that by pleading guilty to these amended charges today, you are giving up your right to have a trial in front of a judge or a jury, and you are giving up all the rights that you would have at trial that are listed on the advice of rights form that you did sign.
Yes, ma'am.
And you did go over these rights with your attorney?
Yes.
Okay, and you understand that by pleading guilty to these charges today, you will not have a trial of any kind?
Yes.
Okay. All right, and is it true then that on August 29th, 2019, here in Wayne, you were operating a motor vehicle after having had some alcohol to drink?
Yes, ma'am.
Do you think it was enough to impair your ability to drive a vehicle?
Yes, it was.
Okay, and that's how you got in the accident?
Yes, ma'am.
Okay. All right, that is a sufficient factual basis for the plea. I've accepted your plea of guilty to operating while impaired, and I have dismissed the operating while intoxicated. Is it also true that you left the scene of an accident?
Yes, ma'am.
And why did you do that?
I can't even say.
Okay. You weren't thinking clearly, maybe?
Yes.
Okay. It is against the law to leave an accident without reporting it to the police. I am accepting your plea of guilty to failure to report an accident. I am dismissing the leaving the scene of a property damage accident. I am also dismissing the no proof of insurance pursuant to the plea agreement. So the next step in the process is you have to have an assessment, a pre-sentence interview. So I can't go forward with sentencing until those are completed. Were you able to get those dates last time or not? You did not?
No.
Okay. All right. So you'll have to go back to the court, and they will give you the date for your pre-sentence interview.
Okay.
And then also they'll give you your date to come back to the court for actual sentencing.
Yes, ma'am.
Okay? So you need to do that today before the end of the day.
Okay.
All right? Anything you want to say to the kids about the experience of being arrested and...
Yes. It would have been a lot better. All I had to do was catch an Uber instead of driving. And, you know, alcohol does impair you. You know, I could have killed somebody. I actually wrecked my truck, totaled another guy's truck. You know, somebody could have been sitting there. It could have been, you know, or I could have just ran off, came off and hit somebody on the sidewalk, could have killed a kid, parent, anything. So it actually, this right here will change my life. But, you know, I'm 44. This is my first mistake ever. So you kids have a good day.
Thank you. Thank you, Mr. O'Day. I appreciate you letting them learn from your experience.
Yes, ma'am.
Thank you.
Thank you, sir.
Okay, our last case, Kelly Reddy. It's the last case on your sheet, and we have gone in order if you've been following your sheet.
For the record, Your Honor, Charles Close on behalf of Ms. Kelly Reddy, who's present with me today, Judge. Your Honor, today is the day and time set for sentencing in this case involving a dog bite attack on another dog. I have had an opportunity to discuss this matter at length with my client. I would point out to the court that my client has never been in trouble before, Judge. There certainly was no intent here. It was a loose animal, and animals can be unpredictable. She is genuinely sorry for the harm that she caused to another animal. She has accepted responsibility to pay restitution to the victim's owner.
Yes, yes, Ms. Reddy. Good to see you again, and thank you for agreeing to come here today.
Good morning, Your Honor.
Good morning. As part of the plea agreement, you accepted the plea agreement to plead to allowing your dog to get out, called dog at large. It's an ordinance violation. In exchange, the court dismissed the unlicensed dog. As part of the plea agreement also, you agreed to pay restitution because, do you want to explain to the students what happened?
Simply put, my dog actually was in its own backyard. However, the latch to my gate was unlocked. Didn't even realize it. Another dog who happened to be injured was walking with his owner, and my dog saw that and went towards the gate, as dogs often do. And unfortunately, since my gate wasn't latched, he was able to go after the other dog, and there was a bit of an attack. And not only was that dog injured additionally to his severe injury that he had already had surgery for, but my dog was injured as well. And this is a dog that I just adopted 9 months ago after the loss of an 11-year-old dog. So this has created incredible turmoil, incredible reservation about fearing that I could ever have something that I am responsible and love hurt somebody else's pet that they are responsible for and love. And it's really important that not only you love your animal, but you're constantly watching them, because sometimes they are more unpredictable than kids.
Thank you for that. Yes. So a large part of what the court deals with there are ordinances. These are laws that are passed by the city council. These are like their laws. This particular one is a misdemeanor, and we did accept her plea at the last hearing, so I'm just going to go ahead with the sentencing. The victim asked for restitution in the amount of $1,986.16, and he brought in a pack of documents showing the vet bills and everything that he had to pay because his pet was so badly injured. So it is going to be a fine of $100. I would normally charge a cost, but I'm not going to because you participated here today.
Thank you.
You're welcome. Restitution in the amount of $1,986.16 that we will forward to the victim. A justice system fee $50, crime victim fee $75, and a building fund fee of $20. And you do need a payment plan for that, correct?
I did, yes.
Okay.
I haven't heard back from my homeowner's insurance. So, may I say one other thing to the children?
Go ahead.
So in the event that my homeowner's insurance does not cover this, instead of roughly $2,000 that I could have done many other things with, maybe a vacation, I now will be paying someone else for the care of their animal because I was irresponsible in not double checking my gate before allowing my dog to be in my yard. And that's a big deal.
Right. And thank you for accepting responsibility so willingly and being willing to come and share your experience here with the students. Having a pet is a wonderful thing, but it does carry a lot of responsibilities along with it. And I think that's especially true if you have a larger dog, you know, the pit bulls and German shepherds and things like that, because they can cause a significant amount of damage. And you've got to really be careful that they don't get out of the yard. And as students, you know, if you have such a dog in your home, make sure that you don't leave the gate unlatched, you know, because I hear that a lot.
It's
too.
easy to do.
It's very easy to do. So.
Not anymore.
Right, okay. Well, thank you, and if you go back to the court, you'll get your payment plan, and then we'll dismiss this once the fines and costs are paid in full.
Thank you for allowing me to participate, Your Honor.
You're welcome, and thank you.
Thank you.
Okay, that does conclude the cases that we had for today. I know that you have lunch in 10 minutes, I believe. So that does leave time for questions.
Okay, tell the judge your name and then ask him your question, please.
I'm Logan, and I was wondering if you guys handle cases with which parent you want to live with?
Fortunately, we don't deal with those cases. We don't have jurisdiction over those disputes. They have to go to the family division of the circuit court, which is downtown. That's a good question, though.
Tell the judge your name and then ask him your question, please.
My name is Ayana Hayes, and did you always want to be a lawyer?
Oh, interesting. I actually, I came to be a lawyer and a judge the hard way. I started off as a legal secretary when I was 17 years old. I worked in a law firm, and I became interested in law and just working at the law firm. And I was promoted to paralegal, which is a legal assistant. And then I decided to go to law school when a tragedy happened in my family. My ex-husband was actually murdered, and that made me decide to go to law school. So it was kind of a long road. I didn't start law school till I was 38 years old. So I went later in life. So my message is that, you know, you really shouldn't give up on your dream. If you have a dream of doing something, keep at it and you will attain it. At that point, I really wanted to become a lawyer, and I did. So, good question.
Thank you. Tell the judge your name and then ask him your question, please.
My name is Ron Riley, and I was wondering, if somebody commit a felony, do they go straight to trial?
That's also a good question. There is a process, the due process that I talked about before. There's something called the arraignment. That's the very first step. There's a complaint and a warrant that's issued with probable cause. The prosecutor and the police work together on that. Then they're arraigned by a judge. So I do the arraignment part of a felony. So every crime that happens in Wayne, I get to do the arraignment. That's meaning I tell the person the charge, and I tell them the maximum penalty, and then I assign a court-appointed attorney for that person, and I assign a date for a preliminary hearing that happens in Wayne. But what happens is if there's probable cause, the case then goes downtown to the circuit court. So I don't actually do sentencings or anything like that. I just do the very beginning part of felony cases.
Okay, tell the judge your name and then ask him your question, please.
Hi, my name is Charles Anderson, and I was asked, how long did you go to college to be a lawyer?
Well, the standard if you go right out of high school and just go straight through, you have to have a 4-year degree, a regular degree from a 4-year university or college, and then you have to go to law school for 3 years before you're a lawyer. And then you have to practice law for 5 years before you can become a judge in this state. It took me 12 years to get my 4-year degree because I went at night and I had a small child. So for me, it took me a long time to get that first degree. Then it took me 5 years to get my law degree. So altogether, it took me 17 years, but it should only take 7 altogether to become a lawyer. But I would recommend it. If you like to read, then I would definitely recommend going into law.
Good question, Cantrell.
Yes.
Okay, tell the judge your name and then ask him your question, please.
Hi, my name is Samuel Perentino, and my question is do you guys deal with like drug cases?
Sometimes.
And my other question was, if it's like a very illegal drug that they use, would it be a misdemeanor or a felony?
Well, that's also a good question. You're asking all good questions. It depends. The answer in law sometimes, a lot of times is it depends. It depends on how much you had and whether you were delivering it for someone else. If you were selling it and delivering it, that ramps up the penalty. If you have a gun, it ramps up the penalty, makes it a felony. If it's just for your own personal use, usually it's a misdemeanor. So if you just are in possession of a few pills or say heroin, which is obviously illegal, then it's a misdemeanor usually. But it just depends on how much you had.
Okay, good question. Thank you. Can you tell the judge your name and then ask him your question, please?
My name is Kamani Williams, and I was wondering, what school did you go to get actually?
Well, I went to 4 different universities to get my undergraduate degree. I went to Wayne State to get my law degree. I didn't go to any school to become a judge. I just practiced law. I did tax law, estate planning, and retirement planning before I became a judge. So there are many different pathways to get to become a judge, but you do have to become a lawyer, and then you do have to practice law for 5 years. So that's a good question.
Okay, tell the judge your name and then ask him your question, please.
My name is Bria, and I was wondering what happens when minors commit felonies.
Yes, they go to the juvenile division, the family division of the circuit court. Our court in Wayne doesn't have jurisdiction over those cases. We do handle some juvenile cases in Wayne, but felonies we don't have the jurisdiction to handle. The courts are divided into different divisions based on the type of case, the severity of the cases, etc. And so we're not allowed to hear those kinds of cases. That would have to go to the family division of the Third Circuit Court.
Thank you. Tell the judge your name and then ask him your question, please.
Oh, okay. My name's Colden, and when I was about like 7, I was attacked by a dog, and it was pretty fatal. But we tried to make a lawsuit on the people, and they moved away, so we couldn't do anything about it. So, is there something we could do about it now or not?
How long ago was it?
Maybe like 4 years.
Well, it's what's called statutes of limitation, meaning that you have to bring actions. This would be a civil action, not a criminal. There are statutes of limitations that apply. Sometimes your homeowner's insurance will pay under cases like that. I don't know if your parents looked at that, and sometimes the homeowner's insurance would go after the person who, the dog who committed it, the family who owned the dog. But maybe the other attorneys here know more about that subject than I do.
I don't know how long the statute of limitations is for that.
I believe it's 2 years.
Oh, he thinks
But
maybe 2 years.
That's just what I believe. You'd have to check that out.
There's a lot of rules having to do with bringing lawsuits, and you would have to look into those rules before being able to go forward.
Just a correction on that, Judge.
Yes.
If the minor was attacked, that would stay the statute of limitations till he was 18.
Okay, there you go. There's hope.
Okay, ask the judge a question. Tell him your name, please.
My name is Maddie, and my question is, if you with somebody that murdered somebody but that wasn't in it, like, why would they go to jail if they didn't do nothing?
Okay,
but they was with them.
what you're talking about is aiding and abetting. Okay, and what our law says is that if you're with somebody that commits a terrible crime and you did anything to help that person commit that crime, you are held just as responsible as the one who pulled the trigger. So, let's say it's your boyfriend and says, drive me to the 7-Eleven. You drive him to the 7-Eleven, he gets out with a gun and goes and shoots somebody inside. You could be charged with murder.
But what if you didn't know?
Well, that's a question of fact for the jury. For whoever hears the case would make that determination. Did they really know or didn't they? But you don't want to be in that position. When I go talk to kids at the high school and things, I tell them, if there's a gun, get out of there. Don't be around. If somebody, one of your friends is waving a gun around, get out of there because of aiding and abetting. If something bad goes down, you could be charged. And you are judged by the company you keep. It seems unfair, but if you continually hang around people who are getting arrested, who are being charged, it's inevitable that at some point somebody's going to think you're involved. So my advice is to pick your friends carefully.
Okay, tell the judge your name and ask him your question, please.
My name's Lillian, and I was wondering if a juvenile committed a misdemeanor, how long would they stay in juvie?
Well, usually they don't go to juvie, okay? That's the worst that can happen when you're a juvenile, is that you're placed in a juvenile detention facility. The cases that I handle are ordinance violations. Nobody gets taken away from their home. It varies, I think. I think the usual stay in a juvenile detention facility is a few months, but I could be wrong. But I don't have the authority to put anybody in a juvenile detention facility. So it's kept for very bad cases, really.
Okay, we got time for 2 more questions. Tell the judge your name and then ask him your question, please.
My name is Alexander Hernandez. I'm asking, well, this happened like, I think 4 years ago when I was still living in Puerto Rico, because I had these neighbors that my family was friends with, but their dog bit my sister, and my dad got angry, so he brought our own dog, and it kind of turned out like something. I did not know what happened, but I want to ask, what would happen? Whose fault would it be? The person that attacked my sister or my dad?
Well, it could be both. I mean, you're not allowed to take the law into your own hands. That's why we have police, we have courts. You're not allowed to go out and take revenge against somebody. It's not allowed under our system. So it could be that both people could be at fault. If your dad did something in retaliation to their dog, they both, 2 wrongs don't make a right, basically. But it depends, a lot of things depend on the facts of the individual case, exactly what happened, before you can make a determination as to who's at fault.
Okay, we got time for 1 more question. Tell the judge your name and then ask him your question, please.
My name is JC. Say if you testified against somebody, at what point would you go into witness protection?
Well, let me say, I've never been involved in a case that involves witness protection, so I really don't know. All I know is what I see on TV. So I don't know if anybody here has any insight into witness protection, but those kind of cases don't come to district court. I mean, most of our cases involve traffic, things like driving on a suspended license, speeding, giving the wrong name to the police if you're pulled over, things like that. But the number one crime in the city of Wayne is driving on a suspended license. So just to all of you, you don't have a license yet, but when you get a license, just pay your tickets or come to court if you can't pay the ticket. Explain to the judge and they'll work with you. If you don't do that, they'll suspend your license. Then it's a lot more expensive to get your license back. And then if you get stopped again, you can get charged with a misdemeanor of driving on a suspended license and could face up to 93 days in jail. So it's not worth it. If you get a ticket, take care of it. That's my best advice.
All right, guys, let's give the judge a round of applause, please. All right.